यहाँ से भी है क्या? कौन? कौन? पूरे हम लगा दिए। Morning. इतना फाइल लेके आ रहा
सो कॉपी सर
या
दूसरा
डिफेक्ट दोनों ले आए हैं गाड़ी में। ये तो डिफेक्ट एक कॉपी ऑनलाइन फाइल करने की जरूरत नहीं ना।
एक नंबर मिल रहा है ना फाइल व्हाट्स नंबर वहाँ
ले आए हैं कल वाला भी आज दोनों डाल दीजिएगा।
एक बार ऑनलाइन डाल दीजिए।
ये नंबर क्या
क्या करना है?
सब में लिमिटेशन पर है सर। कौन सा? मेरे
मेरे पास कोई फाइल नहीं है।
क्या है?
अच्छा
से लगा देंगे।
अच्छा चल रहा है वो उनके साथ में भी तो वही है।
सर बगैर हुआ होगा
वीडियो से ये फाइल नहीं डाल
अभी भी जानते हैं
इसमें तुम्हारा नाम नहीं
एक ही में जानते हैं
सारा विड्रॉ
हाँ
सारा विड्रॉ होगा।
पैसा
17 का टेंडर मैटर निश्चित है कि 18 सौ विड्रॉ ही
18
टोटल लिमिटेशन खाली लिमिटेशन कंट्रोल लिमिटेशन को नलियास का कई अगर लिमिटेशन
इसीलिए दिए थे और टुमारो आज के लिए रखने के लिए था लिस्ट पर वो नहीं है फाइल नहीं
क्या हो सकता है सब लिमिटेशन देख लीजिए
कुछ नहीं उसे चलो
तो राउंडिंग मिलते होगा तो वेट हो जाएगा
इनके पास दे दिया
फाइन नहीं लगे
पानी के लिए करता भी होगा।
और दिए उनको एक नंबर से कहाँ है सर? एक नंबर से
जिंदगी बनने
फाइल देखना है, दे दीजिए।
नंबर 2 पे
हाँ मेरी टाइम है
पार्टी एग्री नहीं
हाँ बैठे ना सर। सुनिए ना, कल एमजेसी 1972-22 जो आज के लिए कोर्ट का हुआ था रखने का, आज नहीं है, क्या बात हुई है? 3 नंबर सर, 3 नंबर कल जो मैंने किए थे 19
नंबर कैसा सर?
22 एमजेसी 18/4
क्या करेगा भाई आप?
साइन कर दीजिएगा कोर्ट नंबर 13 लिख दीजिए।
ब्रीच ऑफ कॉन्ट्रैक्ट तो
और दीपक जी छुट्टी पे चले गए,
सेंड कर दिया रिसाइनमेंट ऑर्डर को। ब्रीच ऑफ कॉन्ट्रैक्ट
और एक 2 स्लिप होगा ना, एक स्लिप अपने पास रख लीजिएगा, इसको दीजिएगा बाहर। हाँ मंडल जी दोनों इधर नहीं ना,
जी नहीं दिखाते
18/4 है ना। क्या किया जाए
सर?
अरे तो ठीक है जब ऑर्डर फिट, अब इसको क्या स्लिप ईवीएम में लगा है ना, ईवीएम में जो नहीं
चांस है उसका, क्या बीमार है
अभी बोला जाएगा। हाँ it appears to be wrongly registered. हाँ और तो कोई दिक्कत नहीं है, फाइल तो सारा था।
इसका साहब कल मेंशनिंग स्लिप दिए थे एमजेसी 1972-2022 कोर्ट ने आदेश दिया था आज को चढ़ाने के लिए, आज नहीं है लिस्ट पर सर।
आपका
जरा सा इन्फॉर्मेशन दिया जाए ना इसका साहब, ठीक है तो इन्फॉर्मेशन दे दीजिए। कल मेंशनिंग स्लिप दिए थे एमजेसी 1972-2022 तो आज के लिए जो है तो कोर्ट का हुआ था कि
विड्रॉवल वाला
रोड लिखने के लिए आपको पूरा डिटेल चाहिए।
भेज दिए।
विड्रॉ लेना है कॉल होने पर है इसका था इसका था
नहीं फाइल तो हम परसों करके आए हैं, कह दिए थे कि मैं
हम लोग को नहीं जानकारी है सर,
हैं
हम लोग को नहीं जानकारी है
क्या करें, एक्सेप्शन से यहाँ भिजवा रहे हैं।
अब तो आज लगेगा नहीं सर, नेक्स्ट डे ही लग सकता है।
देखते तो सोमवार को यही तो होगा ना सर। 3 नंबर
दीजिए सर, रख दीजिए।
विड्रॉ के लिए कॉल होने पर करता कॉल होने पर
लिस्ट से होगा तो कॉल होने पर, लिस्ट के बियॉन्ड है तो आप ऐसे बोल सकते हैं।
नहीं तो लिस्ट पर है कॉल होने पर ठीक।
लिस्ट पर केस एडजॉर्नमेंट कॉल होने पर 1 to 10 ये सब नहीं होता था।
नहीं ना, वही तो कॉल ही होने पर।
वही ना कॉल हुआ तो वही ना।
अच्छा ठीक ठीक ठीक।
ये सीनियर सिटीजन होने के बाद बहुत चीज भुला जाए। हम आपको नहीं कर,
हम 2 साल से
सीरियल 3 और चल गया
भैया है क्या?
हाँ
होने के बाद रोज साहब मेमोरी
18 साल का है
appears to be wrongly listed।
थोड़ा घट
जाना होगा
ना ना, आप बंद रखिए, आपको रखने की नीड नहीं।
अभी कैमरा ऑन
आप
है।
बल्कि
है।
बोल सकते हैं
ऑन है
अभी
हम करेंगे ना उसमें
कैमरा ऑन नहीं ना है।
कैमरा सब चीज ऑन है, ऑडियो भी तो ऑफ रहना चाहिए, ऑन कर देते। Serial 3 appears to be wrongly listed as it is adjourned for 18. Sir, it is there, my lord. Serial number 3, my lord.
18.
It is adjourned for 18/4. Any adjournment for serial 1 or 2? Serial number 3 appears to be wrongly listed as it is adjourned for 18th of April. Any adjournment for serial between serial 4 to 9?
7 my lord 1 week. Serial 7 1 week.
सीरियल 5 my lord।
Serial 7 1 week my lord.
सीरियल 5 7
Otherwise, who is applying for serial number 5?
7 my lord.
7.
Yes my lord 1 week.
That it survives. After 6 years, matter is being listed.
उनका चाची का देहांत हो गया my lord.
Huh?
डेथ कर गए हैं उनके घर में, इसलिए
You will not get any monetary instruction after 6 years. been disposed.
Kindly.
Somebody died. He is saying that somebody died in
my
his
lord.
family.
Good ground to adjourn next week.
Serial number
Next week or 2 weeks.
1 week, man.
Serial 5, my lords. 2 weeks time we can leave.
Why?
Earlier, this case was conducted by another council, and now it has been allocated to me. And previously, some order was passed. I need to verify the developments within these years, my lords. A request case was also filed, and I.
Make clear that no further time will be granted on the next date of hearing.
Any adjournment between serial number 10 to 18?
Lordship. 10, Lordship. 2 weeks time, Lordship.
Serial number?
10. 2 weeks
It
time.
has become infectious. Why you want time?
Also, some instructions also will be required, Lordship.
Monetary instruction you will not get after 6 years.
Only one
What
time.
instruction you want?
This case listed by Lordship from today, Lordship. So, time for instruction.
After 6 years, for the first time, matter is listed today.
Lordship. So, only for the for instructions of the only 2 weeks time, Lordship.
Okay, next week.
Serial number 17, Lordship.
Lordship, serial number
Withdraw
12.
the petition.
17?
Withdraw.
17 withdraw.
See
The respondent or petitioner?
Petitioner, Lordship.
It's serial number 12, Lordship. I pray for 2 week adjournment, Lordship. Counsel for petitioner has personal difficulty, Lordship. So I pray for 2 weeks
2
time
weeks finally, no further time.
of life.
Serial number 15, Lordship. Only pass over for the day, Lord.
15, pass over.
18 will be done, my lord.
18,
Withdraw.
withdraw.
Yes, my lord. That is
20, Lordship. Also withdrawn, Lordship.
Serial number?
20.
Any adjournment between serial number 20 to 27, 19 to 27?
Lordship 20, I permitted to withdraw the same.
21, I may be permitted to withdraw. 21.
My lord, 25, my lord, 2 weeks time.
22 withdraw, man.
26, your
By
lord.
2 weeks.
22 withdraw, man. 26,
Withdrawal of petition is welcome.
26, your lordship, 2 weeks time. 26, 2 weeks time.
2 weeks.
21, I
As a last chance.
permitted to withdraw. 21.
Oblige, your lordship.
Any adjournment between serial number 28 to 35?
30, my lord, 2 weeks.
Your Lordship, 30.
30, my lord.
31, serial number, Your Lordship. Adjournment for 3 weeks.
Why?
Petitioner advocate, due to illness of petitioner's advocate, Your Lordship.
After 3 weeks.
Lordship, 33, I am paying for 4 weeks to file rejoinder. 33, serial number 33, Lordship.
33,
4 weeks to file rejoinder, Lordship.
4 weeks for filing rejoinder.
My lord,
32, serial 32, 3 weeks time to file reply.
my lord, item number 30, my lord, 2 weeks. Item number 30, my lord, 2 weeks.
30. 2 weeks.
Any adjournment between serial number 36 to 44?
Lordship 38 serial number. 38 serial 2 week time.
What do you want?
CGC Mrs. Kanak Verma is suffering from flu. That's why I pray for 2 week
You
time.
have signed wakalat?
Suffering from flu.
No, you signed wakalat.
No.
No. All right. 3 weeks.
Any adjournment between serial number 45 to 52? Any adjournment between serial number 53 to 55?
My lord, outside the list. My lord, serial number 11, I pray to withdraw the writ of application. It has become in practice.
Serial number?
Serial 11.
Serial number 11 withdrawn. You are for the petitioner?
I, my lord.
serial 9 one will be drawn. I am petitioner, my lord. Serial 9.
9 withdrawn.
Yes, ma'am.
Lord, outside the list. Lord, one in my technical bid, my lord, was rejected on 10th, my lord, 10th of this month, my lord. On 12th, my lord, I have filed a writ petition, my lord. On 17th, my lord, is the date fixed for opening of the financial bid, my lord. The problem is, my lord, I will not get, my lord, even token number, my lord. So I have filed yesterday, my lord, and it will be filed, my lord, hard copy today itself, my lord. So any time, my lord, today at 4 p.m., before 4 p.m., subject to my lord's committee.
You can't fix the time.
No, subject to my lord's convenient, I'm saying, my lord.
All right, get verification. Get the file by 2:15.
I've informed the other side also.
Petitioner participated in e-auction for the tender of parking area of Patna Junction South side, your lordship. The last bid price raised by the successful bidder was rupees 1 crore 18 lakh. The petitioner raised bid of 1 crore 36 lakh, but petitioner bid was not accepted by the system, your lordship. Still petitioner is working.
What is the reason? Because you have quoted lowest.
No, I have raised highest bid, your lordship, 1 crore 36 lakh. Successful bidder was raised 1 crore 18 lakh and he was selected, your lordship. Petitioner is still working with that parking area till 25th April, your lordship.
Monday.
Supply.
My lords, from the list, item number 5 may be permitted to withdraw it.
Item number
5, my lords.
Somebody has taken time.
But I am for the petitioner.
Not for the petitioner.
Lordships.
Mr. State Council has taken time.
Oblige, my lords.
Under the heading to be mentioned, serial number 1 versus Arun Manufacturing Company versus the non-company elected for the petitioner fee moving to the court.
May please, your lordships. My lords, by the impugned order contained in annexure 5, my lords, page 55, lordships, without considering, my lord, my explanation, the petitioner has been blacklisted for 3 years, even without, my lord, invoking the power of blacklisting under clause 1.14, my lords, in the tender. So cause notices, my lord, annexure 3. So cause notice was under clause 1.10, and that was also, my lord, promised, because the requirement in the show cause is not found in the bid. And with respect to identical case, my lord had the occasion to stay a similar order, my lords, in which in similar manner it was done.
My lord, that is not identical. Facts are different, my lord, because in that case, suspension was with retrospective effect, my lord.
The show-cause notice, where have you indicated that there is a proposal for blacklisting him?
My lord, because we have referred to the clause 1.10 that itself proposes for blacklisting and debarment, my lord.
1.3.
Yes, my lord. My lord may see at page 26, my lord. That so cause has been issued in terms of that clause itself, my lord. My lord may see page 26, 1.10, clause C, my lord.
Page number?
26, my lord.
Item number?
1.10 C, my lord. Withdrawal or modification of bid after bid submission date and time during bid validity period will result in forfeiture of EMD, and action like blacklisting or debarment shall also be taken against the firm, my lord. My lord, after his price bid was opened, he is submitting a letter that I want change in the unit, my lord. And there was specific...
File your counter affidavit. You state of... Instant... Sir. 10 days. For a period of 3 years. Perusal of the show. Author of the show-cause notice has not indicated by giving proposal why the petitioner shall not be blacklisted for 3 years. Such a requirement is warranted in the light of HighCourt decision in the case of UMC so and so, reported in 2021. Apart, reading of number of judgments in respect of blacklisting, the following points are required to be examined by the concerned authority. So, in view of these facts and circumstances, the petitioner has made out a prima facie case for granting the interim order of staying the operation of blacklisting order related to respondents are directed to file their counter affidavit.
Lordships Annexure 7, they have come out with a tender.
17
When it is stayed, you have to go and apprise.
Only one indulgence, that if the order could be uploaded by late evening so that we can. If the order could be uploaded by late evening so that we can. Deeply obliged. I'm deeply obliged.
No, another person.
Ashish, Dayaji and
Come together, no?
yes, my lord. Himanshu ji, ma'am.
Huh?
Himanshu.
इनके पास paragraph. Patent case.
This order, lord.
Relevant paragraph I have extracted.
Lord, by virtue of last order, Lord, my Lord has directed the Principal Secretary, Lord, to be present here, Lord, and the Registrar of the University, Lord. The Additional Chief Secretary is present here, Lord.
What is the date of regularization?
2011-12, Your
2011-12.
in the year 2011-12, regularized with the university as well.
2011-12.
Yes, Your Lordship.
Government has rejected on what date? Rejected or still file is pending?
Your Lordship, before that answering this question in yes or no, I would just like to clarify one point. In the year 98, in the light of an judgment of this honorable court, full bench, this state government took a decision regarding these type of cases only, who were working on posts which might be admissible against the staffing pattern,
but which were not created. And regarding those, with the proper legal advice of the then Advocate General, the state government issued a letter in the year 1998 in which they laid out certain parameters about these type of cases, and it was circulated to all the universities that all those cases in which a person has been appointed but the post was not sanctioned, yet the post was admissible under the staffing pattern. In those cases, with the full facts, there was a format which was developed and which was circulated with that letter. The cases should be referred to the state government. Now, when your lordship, the question is that whether the state government has accepted or rejected the recommendation. As far as the record which is available in the directorate and in the department, the university has never sent any recommendation for these 129 employees in the light of the circular dated 1998. They have never sent. They have never sent any proposal regarding that regulation. There was a proper procedure laid down, your lordship, in that circular, along with even that who will all sign the format. Everything was laid out, and what informations have to be given, what parameters have to be considered. They never said that. Now, when these petitioners were regularized in the year 2011-12 and under various orders under MJC, when it came to the light of the state government, then Honorable this court in one MJC asked the state government as to what action you have taken against the erring persons who had made those kind of appointments. So the state government then asked the university that what action, how it has been regularized, and you please take action. University repeatedly wrote to us saying that since those appointments have been done by the then vice chancellors, so they are not competent to take any action against them. So they said that let the department and the directorate might take any appropriate action or decision, whatever they want. Now, in the light of that, then in the department constituted a 3-member committee in the year 2018. The committee went to the university. They examined each and every case, whatever records were made available to that. And based on that, the committee gave a report. Based on that report, the state government said that these cases should be regularized, and they directed the university to terminate them. And then after that, it went to this court, it came in this court, and then in the Reed court, that order was quashed, and then we have come in the LPA. So that is, your lordship, the fact in brief regarding this case. So
whatever the financial burden on the state exchequer, you pass on to the university, because university has committed mistake. And one that apart, rightly or wrongly, regularization has already undertaken in 2011 and 12.
Yes, sir.
How can you reopen in 2019? And that there is to that extent there is a bar in view of the apex court decision in the case of Uma Devi, para 54, if I am correct. You can't reopen the regularization. If any financial burden is fastened on the state exchequer, state has to say that because the university has committed error, they have to take the burden, pass on the financial issue on the university.
Lord, regularization was so far regularization of these rate petitioners are concerned, Lord, that was based on a non-existing order, Lord. The state government has.
All right, Supreme Court says what? Whatever the regularization already undertaken by the respective authorities cannot be reopened after 1/4/2006.
And they were not even competent to issue the order of regularization. And state government opinion.
Take action against them. We are bound by principle laid down by the apex court decision.
In view of the statutes, Lord, section 35, Lord.
Take up this matter to Supreme Court. We will quote para 53 or 54 of the Supreme Court saying that once the regularization is already undertaken, that cannot be reopened.
Your lordship, ultimately, whatever regularization they take, because the universities, ultimately the financial burden will come to the state exchequer, and that is the main issue, your lordship.
Correct, sir. You pass an order, you have an authority stating that due to mistake committed by the university, why state shall take the burden of financial burden. You pass on to them.
Your Lordship, if such an order is passed by the Honorable Lordship here, then that will be sustainable.
All right, we will make an observation.
If we on our own pass such an order, they will immediately challenge this Honorable Court only.
We will pass on. We will make an observation.
Until 27 extended from 2011 to 2019. 129%, maybe 1 crore. And the two difference. Different. Maybe they have to borrow from government. It is only book adjustment.
Your Lordship, the instant order, the circular which was prevalent of the state government was of the year 1998. They were 1998, and they have made the regularization in the year 2011-12. So it cannot be said that they were not aware of that circular. Your Lordship, we are.
Sir, in timely you have not taken any action against the university.
No, Your Lordship, the correspondences have taken place. Your Lordship, we are.
Sir, by the time state take any action, that concerned person will retire or die. This is not an isolated case. Take any number of cases. By the time court make any observation and all, he must have retired or he must have gone. Timely, you people don't take action.
Your Lordship, because it comes to our knowledge very.
2011 to 2019, who has taken the burden of financial burden?
They have utilized the state government of fund, Lordship.
Then you take action against them.
Without approval of the state government.
Sir, please don't give complaint here that university has not followed the government order and they have bypassed the circular and all.
Your Lordship, that we also don't want the employees to suffer. Your Lordship, that way.
Sir, they are working since 1978. Please see, it is not 1 year or 2 years.
The issue is that Your Lordship.
Usually you people don't take action. You allow them to work for years together, even decade together. After one fine day, someone will take audit objection or something. Then from that day it will start.
Your Lordship, this honorable court passed an order in the year 2015 itself about asking about the action which has been taken against the area office.
Different aspect. That is a different aspect.
But even then, the university they refused to take any action.
The register, appointment itself. 70 years to 2011. What is the basis to regularize to such a great person who has appointed? Why these people are not funding?
There is no audit conducted by the state government?
No.
Why? State government, that means, if I am correct, there is a department called State Accounts Department.
Your Lordship, the universities are audited by the AG office only, the Accountant General office.
Then have they not undertaken an audit in order to overcome this, how this money is being spent by the university towards the appointment of these persons and payment of salary and other things?
It has not come to our knowledge, Your Lordship.
That means they are not undertaken. They must report, no? The state government.
Yes.
Then there is a lapses on each and every stage on behalf of the government or the university.
Where is the regularization order?
My lord, they have annexed regulation order.
Annexure 21, page 88.
But I have
The repetition.
and I have brought, my lord, all the orders of regulation of 129 employees. If your lordship permit, then
Contained in Annexure 21 of the writ petition.
Page 88.
88 onwards, your lordship, there are several orders, not one order. Annexure 21 onwards, your lordship, are the orders of regularization.
But service particulars is not given. On what date they were appointed?
No.
that is, my lord, in the various reports submitted by the state, in which, my lord.
No, you are not prepared chart.
Yes, the chart is there, my lord.
Where is the chart?
Chart is there.
It has been shown against some of them, my lord. Kindly have a look.
Page Annexure 21.
My lord, my
Not being shown.
90 has been shown.
My lord, page number 270. Running page 270 of the writ petition, my lord. In that, my lord, the date of their appointment and date of their regularization.
So where is the chart of 129?
Page number 270 of the writ petition.
70.
My lord. And these are the orders of, my lord, original orders, by which they were regularized, and the copy was forwarded to the department. सारा notification जितना उन लोगों का 270 writ petition का वही उस जो चार्ट है, और आपने भी और सब जो चार्ट लगाया उसमें भी है.
किस केस का?
केस कुमार सिंह फर्स्ट केस.
277.
In that chart, my lord, in column number 9, date of
Column number 5.
9.
Column number 5 is the
date of appointment. Date of their joining, and column number 9 is date of their regularization with notification.
Page number 273.
आपका अपील है, डिस्ट्रिक्ट अपील है.
नहीं, ये इसी और
The secretary, 1 or 2 persons must have retired.
My lord, out of 129, 54 have retired, 15 have already died, only 60 persons are in the age of service.
Repeat once again, 59?
54 retired, 15 died, and only 60.
They are on the verge of retirement.
And they are also at the verge of retirement.
We'll take up this matter after their retirement. What is the exact date of that 98 circular?
17/11/1998. Annexed 17, page 73 of the writ petition.
Annexure?
Annexure 17, page 73 of the report.
17 November 1998.
Lord, I have enclosed with the notes list of dates, Lord. That circular is enclosed with the list of dates.
No, annexure 17 to the writ petition or?
Yes, Lord. For Lord, easy reference, Lord, kindly have a look to the list of dates, Lord. The last affidavit, Lord. That circular has been enclosed, Lord.
In the LPA,
in the latest patent appeal. Annexure A1, page 9 of the list of dates supplementary affidavit. Last affidavit, Lord. Is 9, annexure A1 Lord, and the annexure at page 17.
Page number 17.
Yes, my Lord. That is the annexure, my Lord, and notes have been incorporated in page 9. Page 9 of supplementary affidavit, the last affidavit.
The copy was marked to the university?
Yes, my Lord. Yes.
So the circular?
My Lord. Page 17. Lord, these are the executive instructions, my Lord.
Correct, sir. Whether it has been forwarded to the university or not?
Yes, it was addressed to the universities only.
The address to university only?
Yes, sir.
Lord, it has been published in the university manual, Lord. Executive instructions.
Vice Chancellor was a politician? No, that is how state of Bihar is. Without any powers, appointment of chairperson of some board, the board itself is not existing. Appointment is for 10 years. After 10 years, he claims salary.
It is not mentioned to whom it has been issued.
He's saying address to the university. See the last page. The copy of the
published.
It is reproduction of the contents where it is written that it has been addressed to the Vice Chancellor.
Lordship, actually the copy which has been annexed is actually from the printed.
Yes.
That is.
What was the material that it has been communicated to the university? You are saying it's addressed to university, but no material is forthcoming from the this document. What you have produced?
Your Lordship, actually the original copy, then we have to, because it's a very old letter, we have to search the original copy maybe in the old files.
But then assuming that if it is a Xerox copy, it must indicate it is been addressed to university.
Yes, my Lord. Kindly come to page number 73 of the writ petition, Lord.
73
of the writ petition, Lord.
So we have to go to university writ petition.
The briefs are voluminous, my Lord.
Page number 73.
73, my lord, page number 73. Therefore, my lord,
It is addressed to Vice Chancellors of all universities,
all universities, my lord.
of Bihar State.
And subsequent.
And the letter is copied to the Chancellor's office also, and to all the registrars also, and to all the finance officers of all the universities.
Vice Chancellor also. It is addressed to the all Vice Chancellors of the state of Bihar, my lord. Rest are support. हम एग्जामिन किए
Let's take a the present LPA, the appellant state as well as university assigned the part of the land single judge. A bunch of petitions. Mithilesh Kumar Singh and others versus the state of Bihar by CW 12657 of the matter was heard from time to time. On 23, 2020, the following order was passed. Next, today, Mr. So and so secretary, principal secretary or chief secretary?
Additional chief secretary.
Additional chief secretary is present in the court
Vice Chancellor.
to assist in the matter.
Registrar of the
And so also registrar Veer Kunwar Singh University are present in the court. Additional Chief Secretary assisted this court stating that initial appointment of the contesting respondents is not in accordance with law, and further submitted that there was a general circular issued by the state government addressing to the respective university on 17/11/1998 how to take note of material information for the purpose of regularization of ad hoc employees of the who are working in the respective university. So the same was violated by the university. Therefore, further action insofar as regularization of contesting respondents during the intervening period from the year 2011-2012 either contrary to the state policy decision 17/11/1998. Further stated that after regularization of services of the contesting respondent in the year 2011-12, the university never requested the state government for its approval. Therefore, rightly, the state government has taken action nullifying the regularization of contesting 129 employees were terminating their services on various dates, which was the subject matter of CWJC 157 of 2017 and connected matter. If the university registrar or his council is not in a position to apprise this court.
Madam.
Not in a position to apprise this court.
Yes, we are here, madam.
Where is the communication made to him?
Yes, madam.
For approval of regularization.
My lord, my lord.
So they say that they have not received.
My lord, just now, my lord, I have placed all notifications, the copy of.
Sir, where is the letter of the university asking the state government to approve the regularization? Where is that letter?
My lord, page number 220 of the writ petition is the letter of Director Higher Education with
university.
Just now, dated 17th of July 2012 in response to said, which says, my lord, to furnish all relevant documents for approval and
show it to the secretary. Because the secretary says that they are not in receipt of such communication.
And page number 222 is the letter of the university, and my lord, subsequent to that, all the several correspondence were made between the state government and the university, in which university forwarded all the documents and all the time it is being said that it is ineligible. It is my lord.
कौन सा लेटर की आप बात कर रहे हैं?
इसको This is not the
And my lord, all the time from 2012 till 2017, the budget allocation was made. The budget was provided by the state government for making payment to these employees.
Letter was not sent by you. It was sent
Your lordship, the letter with
higher education.
letter of the
your
chancellor.
director higher.
My lord.
Rightly or wrongly regularized.
My lord.
Then it has been communicated for the approval.
My lord. My lord. That.
This is the letter.
Your lordship, the letter which he is mentioning is about the letter which is written by the directorate regarding inconsistencies in the budget which has been asked by the university.
Yes.
It has nothing to do with the regularization.
My lord, page number 22 of my writ petition, in which all स्टाफिंग पैटर्न पर कार्यरत कर्मियों की सेवा का सामंजस्य माननीय उच्च न्यायालय पटना के आदेश के आलोक में प्रथम नियुक्ति की तिथि से
What is the page number?
Page number, my lord, and just now I am reading page number 223 of the writ petition.
Letter dated?
Letter dated 21st of September 2012.
21st of September.
And thereafter, various correspondences have been made between the state government and they never rejected our, my lord, approval.
One sentence.
My lord.
They have regularized these 129%. Please kindly or please approve.
My lord, page number 223, the lordship has seen.
That is with regard to income and expenditures.
अरे भाई उसी में है. Again, my lord, at page 25.
No, you are not answering the court query. The court is asking you a very specific question that you have rightly or wrongly you have regularized 129% 11-12 and you are required to obtain approval from the government. Where is the communication from the university to the state government? State government is denying that you never communicated.
My lord, page number 225 of the same writ petition. अरे भाई अपना ब्रीफ देखिए ना, आपको हम लेटर नंबर बताएंगे वहाँ बताएंगे.
All right, read relevant portion.
उपर्युक्त विषय आपके आलोक में विश्वविद्यालय ज्ञापांक सो दिनांक 20/8 एवं 23/8/11 द्वारा सामंजित कर्मचारियों की सूची सत्यापित कर कार्यालय में आवश्यक.
Communication is not from university.
Yes, कुल सचिव. From the registrar of the university to the higher education, deputy director higher education.
प्रेषक कौन है? प्रेषक देखिए.
प्रेषक कुल सचिव.
नीचे उस सेवा में ऊपर लिखा है सर.
ऊपर सेवा है, नीचे में कुल सचिव. सेवा एड्रेस टू and by
deputy director higher education.
225 page you are reading.
22/2/2013 का चिट्ठी है जो. And thereafter, my lord, ये उसी के लाइन में. My lord, and thereafter at page annexer 6, as per the state government direction, the university constituted 3-man committee. That letter is also there.
No, that is after, in the year 2018.
All letters were of 2000.
Sir, 2012 to 2018, there was no inaction. There was no action on behalf of the government. First time they opened their eyes in the year 2018.
2017, when they directed me to give notice.
But this letter is very specific that those employees who were
There are a series of documents which I can produce. If
23rd of August 2011, copy was attached.
23rd August 2011.
Your Lordship, all the letters of 2011-12, the Learned Council is mentioning is regarding the queries when the Directorate raised queries about the budget. Even the letter of 2013 which he is mentioning, they have simply said that this is the list of the adjusted employees.
Yes.
Never they have asked, as per the Your Lordship, as I have clarified in the beginning, that based on this full bench decision only, there was a full format which was developed, giving all the informations, and they had to ask not only approval after regularization, but it was a pre-approval before regularization. They have not even asked any approval post-regularization. It is only in the form of an information which they are giving.
In the form of information with unnecessary action on your part.
Your Lordship, it has to be clearly in that format, because that format, it is not that unnecessary informations have been asked. The specific informations were asked as to whether the post was advertised or not, whether that post was admissible under the staffing pattern or not, whether the appropriate appointing authority, even if the appointment is irregular, whether the appropriate appointing authority has appointed that person or not. All these things were there in that format.
They have not supplied.
That has never been supplied to the state government.
What action they have taken? Have they rejected?
Thereafter, have you asked them to furnish it in format? What was your response in counter affidavit?
If it is not in format, is it not your duty to reject and asking them to give fresh proposal?
Your Lordship, they have never asked for any approval. It is simply by way of an information, the list of employees. It doesn't contain any information.
At least you should have sought for some clarification. You can't keep the papers under your table.
Your Lordship, that is why we always ask them that this regularization is wrong, and therefore...
So, after how many years?
In the year 2015 we have asked. In the year 2015, Your Lordship, we have asked them to take action against the erring officials who have done this regularization in violation of the state government circular. But they never took any action and kept on writing to us that since this has been, a decision has been taken by the...
University Registrar and his council is not in a position to apprise this court. Is not in a position to apprise this court.
No, they,
high-level committee.
They are relying on some of the document, like annexure.
High-level.
Your Lordship, if I may just say one point, Your Lordship.
Just see to the, what is it called?
Lord, even the university has itself requested the department below to
form a high-level committee.
Conduct a high-level committee, my lord. The university itself has requested.
Counter affidavit filed in CWJC 12657 of 2017, filed on behalf of respondent 4, 5 and 6, which reveals some communication. However, it is not in a specific wording that approval of regularized employees were sought by the university. At the same time, the state council, is a concerned state department, should have sought clarification from the university to the extent what was the object of furnishing or informing the department insofar as regularization of such of those persons. Services have been regularized. In other words, there is a lack of communication among the university and state government. At this stage, it is necessary to take note of as to how the universities audit was not undertaken from time to time, so as to catch hold at a particular stage how the funds are being misused by the university wisdom. In this regard also state has not bothered to verify as to whether time to time audit of the university has been undertaken by the competent authority, and further the reports have been submitted to the state government for taking any action or not. Next paragraph. To be noted that the contesting respondents were appointed on different dates from the year 1978 to 1984. As is evident from one of the chart furnished by the university. Further, it is noticed that out of 129 employees, 54 of them have already attained age of superannuation and retired from service. 15 of them have already died, and the legal heads of the such of those employees were brought on record. And the remaining 60 are still in service. So, on behalf of the university, we submitted that few of them are due for retirement. In the light of these facts and circumstances, whatever the financial burden due to regularization from the year 2011-2012 till date, the university has to take a financial burden. So far as retired persons and such of those employees who died, their financial benefit should be meted out by the state government from the date of their retirement or from the date of death. Till then, university shall bear the financial finance stuff. For remaining 60 employees who are all still in service, the university shall take the financial burden.
In budget allocation, my lord, they were providing till date. Where is the fund in the university to take up the financial burden, my lord?
Take up this matter to Supreme Court, sir.
My lord,
take up this matter to Supreme Court.
Since my lord, every record is before you.
Allow us to give dictation. Don't disturb.
On this point, since you are.
Sir, don't disturb while giving dictation. What is that?
Take financial burden till date.
Till date. Please stop. Next one. The state, the financial benefits shall be calculated and dispersed by the university insofar as the in-service candidates within bracket if any arrears were required to be paid. Similarly, to such of those retired and such of those employees died, their monetary benefit shall be calculated by the respective state as well as the university with reference to the observation made abroad. Same shall be paid to the respective parties. So if any of the employee or a retired employee or a dead death of an employee is not entitled to, in that event, respective parties like a state and university must pass a detailed speaking order as to how they are not entitled to any monetary within bracket arrears. In this regard, order shall be passed and communicated to the respective parties. To this extent, the order of the learned single judge modified. Writ LPA allowed in part.
My lord, with regard to financial burden, my lord, nowhere the state government ever said not to make payment. When they directed me to not make payment,
Audit has been undertaken. Audit.
My lord, the audits were regularly being taken. Regularly, audits were being taken by the state AG.
All right. If the audit has been taken, if the state has already allocated budget, the burden is on you to bear the financial. They have already granted budget, no?
Now from this day, from this order, my lord, they will not make budget allocation for these employees.
Final litigation.
My lord, but now, my lord, as per your lordship's order, they will not, my lord, provide me. And the university has got no fund for making payment.
University is so helpless.
Yes, my lord. So far,
how can you say that? Request the chancellor and get an order from the government.
Unless
my lord,
the
vice chancellor itself has written to the department. If you place all these materials before the chancellor, and chancellor will take care with the government and get a fund from a particular fund, consolidated fund.
Unless your lordship.
No.
The chancellor will not entertain the types of my lord.
Sorry, Mr. This is our order. Call the next case.
My lord, your lordship. Since on the question of budget, they have not anywhere said that.
That is not the issue in the
the state has never said that we have not allocated my lord budget.
All right. If they are not, if they are denying that we are not allocated, then how did you pay?
Then we cannot pay.
No, you have already paid, no?
From the budget allocated by the state.
Therefore, they will continue to allocate the budget.
From this order, from order today, afterwards, they will not allocate. Taking the benefit of this order, they will not allocate for the remaining.
No, for future they have to accept the financial burden in future from today onwards. As on today, budget has been given to you or not?
For these 2 or 3 years from the date of order, they have not.
There are.
They are not.
Financial manual of the university or a state of Bihar financial code. There is a provision how to reconcile. You please go through that. That can be done. Actually, it is a book conversion.
My humble.
If excess is paid, next year it will be adjusted like that.
My lord, my humble request would be that
all LPA stands before
my humble request would be, my lord, observe a line so that the university may.
No, due to error committed by the university, we are.
University has not committed any error,
Why you are not followed 1711-1998 circular?
My lord, all the universities of Bihar.
Please answer. 1711-1998 has not been complied. Why? Before regularization.
But they were regularized pursuant to a absorption committee constituted by the university. The report of that committee was forwarded to.
Then how do you overcome 1711-98, which has been addressed to universities?
But that has been, where is the format under which, my lord, these...
We are not concerned that. You should have sought for clarification from the government.
Lord,
the 17/11/1998.
All the time the government asked clarification, the university furnished the same. They did not take any action.
All right, we will impose the exemplary cost on the university, stating that they have disobeyed the directions of the government.
We have not disobeyed.
17/11/98, where is the complaint? 17/11/98 has been addressed to you. Whether have you complied or not?
My lord, from the date of notification and from the date of their regularization till the date of issuance of so-called notice to all.
Sir, as on the date of regularization in the year 2011 and 12.
My lord.
Why you are not referred 17/11/98? Why you are not complied? Directions have been given to the university.
Or these, my lord, they
you want to still argue? You want to still argue?
I am just submitting your. I am not arguing. I am not arguing. I am just submitting that.
No, dictation is over. Then where is that? No, if you are still arguing, we'll record.
Then this submission may be recorded that from the university has got no fund to make payment.
Huh?
The university has got no additional fund.
Your headache. It is your headache. Why we should take all those instances?
I am not saying my submission will be recorded, madam.
Then we are going to impose cost.
On the threat.
Or take down. At this stage, council for the university submitted that from time to time budget allocation was granted by the state. In the guise of implementation of the present order, there may be a certain hurdle to the extent that the state may not allocate budget. Such a issue could be resolved by the government and university for the reasons that there were inaction on behalf of the university in not taking note of government specific circular dated 17/11/1998 before undertaking the exercise of regularization of 129 employees in the year 2011-2012. So at the same time, state government has not apprised this court. The budget has been allocated in the absence of material information whether 129 employees, their appointments and regularization was in order or not. Further, there is an error. There may be error insofar as the audit of the university undertaken during the intervening period from 2011-12 to 2015-2016. Further, the state government is not in a state department is not in a position to apprise this court. The state as well as university were not in a position to apprise this court whether allocation of budget from 2016 till date has been allocated by covering 129 employees or not. Therefore, the university and government and the university should resolve the issue in order to overcome the hardship of the 129 employees. If there is any difference of opinion among state government and university that does not result in hardship to 129 employees, the state being a model employer must take special interest in order to resolve if there are any shortcomings insofar as allocation of budget to the staff. With the above observation, LPS so and so.
Lordship, may I just submit one sentence if you permit? Your Lordship, when it has been correctly held and your Lordship has finally, after all the arguments have held that these regularizations were not proper as per the directions of the state government. Lordship, may I request that just one line may be added enabling the state government to take appropriate action against the then authorities who have undertaken the regularization in violation of the circular.
The state government is helpless?
No,
then
Lordship.
take action.
I'm just saying when your Lordship has dealt with all the aspects
It's too late. Otherwise, you give the details of such of those persons who are still in service.
The university has itself accepted their fault. That letter has been supplied.
Then initiate criminal case.
They have written letter
Breach of trust. Breach of trust. Initiate criminal case.
They have requested the state government to constitute a high-level committee, Lord.
In fact, the state government itself said that a vigilance inquiry has been set up. Then, if they have already taken the step.
Lord, the letter itself indicates that we are helpless. We cannot take action against the Vice Chancellor.
Vice Chancellor is, what is his name and when he was appointed?
Then Vice Chancellor.
No, now.
The Vice Chancellor has been appointed just 4 months back.
Then you are not taken any action while he was in service.
They have accepted their fault, Lord.
That is the reason. Timely action is required to be taken.
Now, yes.
Obliged, Lord.
Serial number 3 is wrongly listed.
Salary had been with them. Salary should come.
Monetary means what? That is the reason I have used the word monetary.
On next date, there are certain other LPAs also. I will supply the number.
Still, some more litigations are there.
There. In this batch, there are some left.
All right.
I will give.
Give the number.
56 LPAs are before my Lord today.
Not 50.
50.
There are 50.
All right. Today we have completed our.
On the second quota, there are 4 or 5 LPAs more.
You can give the numbers, they can be notified and then be covered up along with.
I will give.
Why you kept those LPS?
No, my lord, in fact.
Take chance, is it?
No, not for chance, my lord. Since your lordship has directed, given some time to remove defect, that because in all other cases, my lord, the only affidavit filed is in this case, and in other cases there are no affidavit. But the office says to file all the documents from where, my lord, we can.
My Lord, the 50 LPA, my Lord, there may be defect, my Lord. Defect may be ignored.
Yes, my lord.
What defect?
The matter, my Lord.
In some, my lord, LPA ways to supply some this copy, that copy.
Defect is still exists. That may be ignored. Minor defects may be. Because they have filed, my Lord, with defect. Defect have not been removed.
So the sentence last minute. If any pending IS stands disposed of.
Yes,
my lord.
Similarly, if any office objection is yet to be complied, the same is ignored since we have disposed of all these LPS.
Yes, sir.
Obliged.
Strongly listed.
Under the heading for admission, serial number 4, Shiv Kalyani Construction Private Limited versus the State of Bihar for the petitioner Sri Ravindra Kumar Sinha.
He has been taken out of debar list.
Later on, he has completed the work. So,
It has become infectious.
Superintendent engineer has recommended that his name be removed from the debarred list, Your Lordship. The counter affidavit we have.
What is the date?
It is annexed D, Your Lordship, 8/2/2000.
But the order is passed by Chief Engineer.
8/2/2018, Your Lordship.
8/2/2000?
Superintending engineer has recommended to the chief engineer to remove his name from the debarred list.
And thereafter? Only recommendation. Chief engineer has acted upon the recommendation.
Yes, Your Lordship.
Where is that order?
Order has to be brought up there. It has become
It is only up to that.
और सब रेस्पोंडेंट स्टेट पटना IPS सब रेस्पोंडेंट हम हैं जिसमें अपने
None appears for the petitioner. In the instant petitioner has prayed for the following. The respondents have filed counter affidavit. The recommendation by the superintending engineer on 8/2/2018 to remove the petitioner's name from a department in view of the fact that petitioner has executed the work. A formal order was importantly passed by the chief engineer in removing the name of the petitioner from the debar list. So, as on today, the same has not been placed on record. The chief engineer has already passed an order. Then nothing remains in the present litigation, present list. So, in the event of not passing of any order based on the recommendation of the superintending engineer dated 8/2/2000, in that event, the chief engineer pass a suitable order and communicate the same to the petitioner. The above exercise is completed within a period of 2 months from the date of receipt of this order. Writ petitions and dispose of.
Serial number 5 is withdrawn. Serial number 6, Santosh Kumar Thakur versus the State of Bihar for the petitioner Vijay Kumar.
Against page communique my lord, annexure 1 at page 12 my lord, the petitioner filed the present date application my lord, by which it has been communicated that the agreement will be cancelled and you will be blacklisted my lord. What happened in this case my lord, that a work for construction of a bridge was allotted to the petitioner my lord, and accordingly agreement was executed by the annexure 2 my lord. And thereafter, when the work was started by the petitioner, my lord, thereafter the annexure 3 was issued by the junior engineer, my lord, directing the petitioner to immediately stop the work because the work will be started after selection.
Where is the blacklisting order?
Against the press communique, my lord, the present date.
No, blacklisting order, what is the date?
Till date, my lord, no order has been passed, my lord.
Therefore, your writ petition itself is
kindly see, I am still ready to complete the work, my lord. I have prayed for extend the time 2 months, my lord, but despite of my prayer, my lord, no extension was granted, my lord. Kindly see annexure 3 may kindly see, my lord, immediate.
Where is the agreement copy?
Agreement is annexure 2, my lord.
What is the clause? If there is any dispute?
There is F2 agreement, my lord, and the time for completion of work was 1 year, my lord.
What is the court is asking you?
Several direction has been given to him.
No,
complete the work.
the agreement, what is the clause? If there state government council, you don't know what is the whether blacklisting action has been.
Blacklisting order has not been transmitted. There was a direction
to threatening petitioner. We will blacklist, or blackmailing.
no, not blackmailing, but there was a direction to complete the work. Only he has completed 50% work.
The guise of completion of work, the executive engineer was blackmailing him. They will propose for blacklisting you.
Lordship, he has only completed 50% work, and direction has been issued to him to complete 100% work.
Whatever it may be, take action and complete, whether in his favor or against him. It's taken on in the instant petition. The petitioner has prayed for the following relief. Even though writ petition is not maintainable, having regard to the fact that work was required to be executed in the year 2017-2018 or 2019. So for not completion of work, certain proposal was sent for taking action against the petitioner. Even to this day, there was an inaction on the part of a respondent, concerned respondent. So therefore, the petitioner is hereby directed to submit a detailed representation to the concerned authority. On representation, the concerned respondent
executive engineer will
pass a detailed order and communicate the same to the petitioner. No, work is 2010.
And in the year by annexure 3, my lord, the work was stopped.
Work in 2009, Lordship, and completion of till 2010.
By annexure 3, my lord, by order dated 21/2010, my lord, the work was stopped, my lord, by the junior engineer on the ground that after verification, after selection of
people don't produce the proper document. Where is the agreement?
Agreement I have annexed annexure 2, my lord.
Where is that clause? If there is any dispute,
in the agreement, my lord, there is no clause, my lord. I have gone through the entire agreement.
Go and file a civil suit.
There is.
You have placed the complete copy of the agreement and the document.
I have annexed all the entire agreement.
Sir, if there is no clause, then you have a remedy of filing civil suit.
So for the authority may kindly be directed to consider and pass region.
That's what we have passed.
Passed. Okay. Time may kindly be framed, my lord, either 2 months, 3 months.
First of all, you don't have right.
Serial number 7 is adjourned for next week. Serial number 8, Sakuntala Foundation versus the State of Bihar.
Your Lordship, in view of counter affidavit filed on behalf of respondent number 5, the instant writ petition appears to have been infructuous.
And
As
for
per,
the reason
as per
that
amendment in
yes,
number 6.
that is page 19, the specific clause is for that
the
is for
very
3 years.
very tender notice has been cancelled.
And last
That
page
is
of
an
the
extra
bill, last page of the bill, very first column 18. The agreement will be for 3 years only. Therefore, it has already expired in the year 2020.
Sir, has read for the following relief. When counsel for the respondent.
Respondent is state 5.
Respondent?
State. Respondent number 5.
Respondent number 5. It is stated that the present petition do not survive for consideration. It has become infructuous. The right of the aforesaid submission read with the counter affidavit, the present petition has become infructuous. Accordingly, the writ petition stand dismissed as infructuous. That as infructuous.
Serial number 13, Mohammad Aslam versus the State of Bihar arrest for the petitioners Sri Ram Kumar Singh.
Huh? Withdraw.
Serial number 14, Yes Enterprises, Offset Printers and Government Supplier versus the State of Bihar for the petitioner Sri Suman Kumar. Serial number 14 for the petitioner Sri Suman Kumar.
Become infructuous.
Lordship become infructuous, Lordship.
Taylor. Instant petitioner has paid for the following relief. There is no interim order insofar as staying the subject matter of a tender notice dated 12/8 that it has already spent its force. Hence, the present petition stands disposed of as it has become infructuous.
Serial number 15 is passed over for the day. Serial number 16, Viswas Security Services India Private Limited versus the State of Bihar for the petitioner Sri Vikas Kumar.
Appearing on behalf of the state, 2017-18 tender which was issued, that should be determined, that should be passed. It has become infructuous now. Your Lordship will see the prayer. Found was that earnest money was deposited in name of one Manoj Kumar, employee of the company. But tender was of 17-18. So by that time, some other person might have been working.
None appears for the petitioner. The instant petitioner has prayed for the following relief. The subject matter of litigation already spent its force of any interim order. Moreover, NSC certificate which was required to be deposited by the petitioner company was not ordered. On the other hand, NSC certificate stands in the name of one Mr. Manoj Kumar. On the other hand, managing director of a petitioner company is Sir Vinod Kumar Sinha. In other words, NSC certificate furnished by the petitioner company neither stands in the name of Viswas Security India Private Limited nor in the name of Managing Director Vinod Kumar Sinha. Therefore, there is no infirmity in rejection of the petitioners.
Serial number 17 and 18 are withdrawn. Serial number 19, Messrs. IVRC Limited versus the State of Bihar for the petitioners, Ms. Namrata Mishra.
Kindly pass over for the Lordship. Sometime argue in this case, Lordship.
Yes, what is it?
Lordships, she is requesting for the Passover.
What is that? No reference in the index. You are a proxy counsel? Have you filed wakalat?
Yes.
Huh?
नहीं.
You are not filed your wakalat. Is it of notice?
Even for decision of
Student order is without notice.
May only be passed through for the day, Lordships.
Prima facie impugned that the decision of the respondent in rescinding the contract on 24/10/2017 is not after due opportunity of notice to the petitioner. Opportunity release this matter on Monday.
Highly obliged.
Serial number 20, 21 and 22 all are withdrawn. Serial number 23, Mr. Satyar, please signing construction company versus the state of Bihar for the petitioner Sriraj Kishore Prasad.
है ये.
The absence of nothing remains in the present petition. In order to give an opportunity, release this matter on Tuesday.
Serial number 24, Messrs. SK Builders Proprietor Sanjay Malhotra versus the state of Bihar and others for the petitioners Sri Lakshmi Kansarma.
Lord, may kindly pass on this.
Is it after notice?
My lord, yes, my lord. I pray for. My lord, yes, my lord.
Where is the order?
My lord, I pray for 3 weeks' time for filing counter, my lord.
Remind finance.
Yeah, we need lots of.
Doctor, you are. Blacklisting. What it is?
This is recommendation.
Debarring him and putting him in blacklist. Recommendation for putting him.
Writ petition is premature. It is only a recommendation.
No, my lord, action was taken and the agreement was decided.
Recommendation.
In action 1, my lord, you can receive. And last 2 occasion time was granted to the respondent for filing counter affidavit, but still they have not filed. And since
where is the word contract is terminated?
That is, my lord, the operative portion.
No, in the
action 1.
25 and 26 show us the word that the contract has been terminated.
अंतर के द्वारा एक नामा को विखंडित करते हुए, that is विखंडित करते हुए एक नामा के विरुद्ध पूरी जमानत की राशि कटौती के साथ राजसात किया जाता है.
Notice of termination.
That is not there, my lord. They say they sent the notice on 15 to 17, 27 to 17,
and totally order
17.
Work.
That is reminder to complete.
No, where is the specific notice?
No notice. No notice is there, my lord. No notice is there, my lord, and since last
3 weeks time, my lord, to file comment.
Not even 1 minute.
I have taken
Section by 215. We'll set aside and remand the
Monday, my lord, Monday, my lord. Monday, I'll take oral instruction, my lord.
We find prima facie that the impugn termination of a contract is without notice. The counsel for the respondent is hereby directed to secure instruction whether was there any proposed notice insofar as termination of contract of the petitioner or not. Monday, sorry, Tuesday.
Tuesday, all right.
Serial number 25 and 26, both are adjourned for 2 weeks. Serial number 27, Mrs. Mati Infrastructure Private Limited versus the State of Bihar. On the petitioner, Ms. Ulla Kumari.
My lord, the main thing, the petitioner is a registered contractor under proper category or not. Only a question is involved.
What category? What category?
First NIT, kindly see page number 15. Kindly see 15. Para 10. 15. Page number 15. Serial number 10. कोई भी समुचित श्रेणी एनी रजिस्टर्ड अंडर proper category can participate in the tender. Only question involved the petitioner. Now the respondent kindly come to the page number second NIT 21 serial number 11.
So what is the reason for cancellation?
Because petitioner is not under registered in the department of BCD, Building Construction Department. First NIT, we have participated in the tender.
First NIT is, what is the date?
Date, page number 15.
No,
date is 10th July 2018.
The second one?
Second, 31 August.
31?
August 8, 2018. There are a great respondent manipulated in the both NIT. First NIT says under any registered can dealer participate in the tender?
Right? Cancel, extend, bid without emergencies.
Without any
By annexure B.
Clause 25, first NIT.
First NIT, 15 page number.
16, page number 16.
16, sorry. Serial number 16, 10.
Next page, clause 25.
25.
Yes.
Then for non-responsive of the petitioner, my lord, I will state.
Just a minute, let him answer.
5.
Yes.
Read petition, yes, ma'am.
Read, sir.
Yes, my lord. Read petition. In my read petition is 25.
Read petition.
Mail, Gmail.
Not in read petition. This annexure.
Page 16, 16. You have a copy of the read petition?
Yes, yes.
Page number 16.
16, yes, my lord.
Part of first tender.
First tender, yes.
Condition number 25.
Condition number 25.
Read.
Yes, my lord. Without knowledge of बिना
Don't give explanation.
बिना कारण बताए निविदा को अस्वीकृत करने, रद्द करने, तिथि विस्तार करने का अधिकार सक्षम पदाधिकारी को सुरक्षित है. Yes, my lord. I am agree with you. But I have participated in the tender under proper registration under category of the.
You are not concerned with that. Have you questioned this clause 25 is in violation of some provision? Because they can't impose such condition without reason.
Without.
Correct, but you should have challenged this. We should have set aside.
Yes.
Should have interfered.
Yes, I challenge, sir.
No, you have challenged condition number 25. We are asking you.
No.
Then because you are bound by it.
My lord, only reason was assigned and cancellation of my bid. Only.
Sir, in their condition, they have reserved their right to cancel or withdraw, whatever it may be, without assigning any reason. They need not assign reason. They can simply cancel.
It is a.
But my lord, my condition is contract to my contract with the para.
What happened to retender? There is a
reason has been assigned because the petitioner is registered in class 3 contractor, my lord. The requirement is registration with class 2 contractor, my lord.
You have not mentioned that thing in your NIT, first NIT.
Yes,
but my lord, the tender regulation committee rejected the petitioner tender was found non-responsive for the reason, my lord, because he is a contractor, class 3 contractor, so he did not fulfill the criteria. According to the my lord, the Bihar Tikadari Nibandan Niyaमावली 2007 में लॉर्ड, अगर इसमें देखा जाए इसमें रजिस्टर्ड कॉन्ट्रैक्टर श्रेणी 2 तक 70 लाख से लेकर 2.5 लाख तक में कर सकता है, जबकि ये टेंडर अच्छी वो 1,94,00,000 का है.
My lord, the petitioner is registered under second class company. He can participate in up to 350 crores.
Annexure 1 देखा जाए जो admitted he was class 3 contractor में लॉर्ड. Annexure 1 से appears में लॉर्ड श्रेणी 3 में है.
Or you can participate in tender. Council,
Follow the which kind?
From 70 to 2.5. It is one.
fall under second category. Class 2. But here is a class 3 contract. No, even assuming that, what is the reason for cancel? Have they assigned? What about the other category?
My lord, kindly see the page 14, Annexure 1.
Why the first tender was cancelled?
Then was resigned, my lord, by Annexure B, my lord, to my contract affidavit, my lord, because he did not fulfill the, my lord,
Just because he has failed to fulfill certain conditions.
My lord.
What about the other bidder?
Other bidder, only one bidder come, my lord, therefore, according to, my lord, the finance circulars, my lord, region administration, therefore, my lord, the occasion to arise, my lord, to re-tendering the matter, my lord.
My lord, petitioner is registered under second class contractor. Kindly see the Annexure 1, page 13.
ये सैलरी लिखा हुआ है जो
ये नहीं रहे.
Because he doesn't fulfill the category 2.
The present position of this petition, there are 4 bidders.
So there are two issues. First, this tender was cancelled, and prior to that, your bid was rejected. Technical bid was rejected on the basis of this VR Contractors Rule 2007. That you were not a Class 2 contractor.
Yes, my lord, I am Class 2. Kindly see the page 14, Annexure 1. He is telling कि मेरे विभाग में रजिस्टर्ड होना चाहिए. अब यूपी वाले कहेंगे कि नहीं, बिहार से पास नहीं, बिहार के मैट्रिक पास को हम नहीं लेंगे. ये डिपार्टमेंट RC DFPWD ये रजिस्टर्ड Annexure 1.
तीसरी सैलरी मतलब क्लास 3
है, झूठ क्यों बोल रहे हैं?
तीसरी सैलरी लिखा हुआ लगा है.
वो BCD का है, क्लास 2 का देखिए ना, वो Annexure लगा हुआ है. झूठ नहीं.
Where is that document that you are Class 2 contractor?
Yes, my lord. Annexure 1, page number 14. RCD पथ निर्माण विभाग प्रमाण पत्र मालती इंफ्रास्ट्रक्चर क्लास 2. इनका कहना है my lord कि मेरे यहाँ रजिस्टर्ड होना चाहिए. हाउ इज इट पॉसिबल? Any contractor, NIT conditions has already clearly says any contractor can participate, registered contractor. The petitioner is already contractor registered.
Are they indicated in the tender notice
The statement has been given by the learner friend. केवल माय लॉर्ड हम भवन निर्माण विभाग में नहीं है रजिस्टर्ड, इसलिए हमारा
लगाएंगे.
ये भी लगाए हैं हम. उसके बाद देखिए बताइए.
The tender notice, have you indicated that Rules 2007 is applicable? Conditions stipulated in Rules 2007 is applicable?
Rule 2007 applicable in all matter, my lord.
All matter, correct. But why you are not indicated in the tender notice? How do you expect a bidder whether he is required to comply the Rules 2007 or not? You must indicate, no? Rules 2007, whatever the condition stipulated in Rules 2007 is applicable to this tender. On the other hand, you are not mentioned that only Class 2 contractors were required to participate in the process. Class 2 and above.
Class 2 means क्योंकि amount it will depend upon.
Now where is the requirement that he is required to register in social department? Then how can they say? All right. First, the first tender. We are concerned with the first tender.
Registered contractor in appropriate class. Right.
Under 2007 rules,
Sir, in the tender notice, there is no indication that
tender notice, my lord, details are given on the website, my lord.
Sir, where is that 2007 rules is applicable to this tender?
My lord, big manipulation has been committed by the respondent. First NIT, any registered contractor, and second NIT, only BCD proper registered contractor under proper category. Second NIT में इन्होंने दे दिया. What is this? First NIT पर हमने participate किया है.
Participate to किया नहीं, but you have found none, but that order has not been challenged.
I have challenged.
No, not challenged. That fact has been suppressed by the petitioner by the writ application. In the technical bid, he was found non-responsive. That order has been not challenged. Now he challenged the retendering the matter. He said that I have not given any information about it.
What is wrong in it? Anyway, status quo is there.
Status quo, my lord.
That means you are not undertaken for construction of boundary wall and main gate of a government polytechnic.
My lord, no.
So
after that,
so we'll set aside the retender, continue with the first tender.
Only respondent wants to allot the tender to his choice bidder. Only game is playing.
Game? What's a game?
My lord, first NIT says clearly that any registered contractor can participate in the tender. The petitioner can participate with the class 2 registered hold. And second NIT, he has changed the conditions. Only BCD class 2 registration. How is it possible? RCD registration is equivalent and acceptable to all departments.
Competition.
The respondent is keeping up till now the EMD of the petitioner.
Huh?
EMD.
Want back? You want back?
No. I want to award.
Huh?
Award my.
Then why are you saying EMD and all?
Still one step, you cannot audit that tender straight away. There is one more bidder.
Yes,
If
my lord.
that rate is allowed,
The financial bid shall be open. Who is the lowest one shall be awarded. By humble submission, the financial bid may be opened.
To counter. Tender, have they indicated what is the rule for cancellation of first one?
My lord, kindly see the annexure 4. The approx side appears the 4 bidders were qualified. Only one bidder is qualified. What is annexure 4, page 20.
Why this second bid was being invited?
Their contention is only one bidder.
Technical. Class 3. How they have arrived at the counting? I don't know. After this second tender, Anish Shankar was evaluated and State Council, whether you have communicated this document of cancellation of the technical.
My lord, I have communicated, my lord, to the council for the petition by annexure C, my lord. Annexure D, my lord. Annexure D, my lord, page 28 to my counter affidavit, my lord.
Sir, have you communicated this decision?
And communicated with council for the petitioner, my lord.
Why are you communicating with the council?
And just
Very important documents issued by the Commissioner RCD, kindly see. Without, in this letter has been direction given to the all department. Prior to disqualify the bids, any bidders may be granted a chance to hear and the result of the technical bid examination must be published on the notice board, but has nothing done in this regard.
But he is about both class 2 and class 3. He has completed a certain amount of work. Have a lot of money. Can I register for class 1? Is it called? It is civil. Qualification. To state of in the instant petition, petitioner has prayed for the following relief. Petitioner is a class 2 contractor as well as a class 3 contractor, Patna. Class 2 contractor in in BCD class 3. Building construction department class 3. He had participated in the process of tender notification for construction of boundary wall and Government Polytechnic Commercial. Was notified on 10/7/2018. Process of tender proceeded up to the stage of opening of technical bid. Thereafter, the official respondents noticed that the petitioner fulfilled category like a class 2 contractor. So, the building construction department thereafter official respondents noticed that there was only one bidder, therefore they proceeded to cancel and re-tender the matter on 30th August 2018.
paragraph, the present petition is presented by the petitioner. Next for and counsel for the petitioner submitted that the tender notification there is no prescription of that contractor, class 2 contractor must be the building construction department. In the absence of any specific condition imposed in the tender notification, to the extent that bidder must be class 2 contractor with a BC department. Further, pointed out that there was no indication in the tender notification to the extent that Rules 2007, what is the title?
Bihar contract.
Bihar Contractors Service for short, Rules 2007. Further submitted that no doubt the respondents have every right to cancel or withdraw the tender notification in terms of clause 25 of the tender notification. At the same time, reasons are taken into consideration of petitioner's technical bill that he was not registered as a class 2 contractor with the BCP department. Such a reasoning are contrary to condition imposed in the tender notification dated 10/7/2018. Per control and counsel for the respondent to the aforesaid contentions and submitted that was required to register as a class contractor with the BCD. Further, it is submitted that after rejection of petitioner's bid on technical only one remained. Such an event, tender is required to be re-notified in terms of Rules 2007. To have heard the land councils for the respective parties. Huh? In terms of financial rules, title
Tender circular.
Finance.
Huh?
Tender circular.
Finance or सूचना संख्या.
What is the title of the rule?
That's वित्त विभाग बिहार पटना का सूचना संख्या फाइनेंस दिनांक 30/9/2016 का आलोक में.
Title. This is rule or instruction?
Ordinance was finance department का ordinance अधिसूचना.
Correct. Finance department has issued an instruction.
My lord.
Circular numbers 7806 dated 30th September 2016. What is the last sentence?
Heard the land
councils for the respective parties. The subject matter is relating to construction of a boundary wall and main gate of government polytechnic year 6 year pursuant to the 10/7/2018 first tender notification. The reason of petitioner's technical bit with reference to the fact that he was not registered as a class 2 contractor with the BCD department would not be a hurdle for the reasons that in the tender notification dated 10/7/2018 there is no condition that class 2 contractor must have registered with the BCD department. On the other hand, it simply indicated that registered class 2 contractor who is the documents, it is evident that the petitioner is class 3 contractor with the BCD and class 2 contractor with the road construction department. The absence of stipulation of that class 2 contractor from BCD, the official respondent cannot reject the petitioner's claim under class 2 category. He is already holder of the class 2 contractors registration with the RCD department. Therefore, rejection of the petitioner's technical bid is contrary to tender notice dated 10/7/2018. Rules 2007 have been taken note of by the official respondent without informing the bidder with reference to tender notice dated 10/7/2018 to the extent that they would follow the terms and conditions imposed in Rules 2007. So, in the absence of such a stipulation, to the extent that Rules 2007 will be followed for the purpose of completion and the process of 10/7/2018 tender notice. In view of these facts and circumstances, the petitioner has made out a case accordingly. Pre-tender notification dated so and so stands set aside. The concerned respondent is hereby directed to proceed with the first tender notification dated 10/7/2018 and complete the same within a period of 3 months. The aforementioned direction would not have been granted by this court in the absence of any interim order. On the other hand, in the present case, interim order is operating from 24/9/2018. Hence, the petitioner has made out a case accordingly. The petitioner stands allowed.
Serial number 28, Naseeb Lal versus the State of Bihar for the Indian Street Legislative Festival.
Lord, so this case I am appearing for respondent number 6 to 9. Lord, in the writ proceedings, Lord, we were not served with notices, we didn't participate. So I don't have a copy of the brief of the writ petition, Lord.
No, you are appearing for?
Respondent number 6 to 9, Lord.
9.
My lords. Notices were issued, my lord, by order dated 19/12/22. And in furtherance of that, my lord, I have entered appearance.
Why you have been implemented as party in the absence of you being party in the writ petition?
We were parties, my lord, but we were not heard, we were not required to be heard. The writ was dismissed. Therefore, they have come in appeal, my lord.
No, at the time of admission stage itself, no dismissed.
Come
Without notice to the private respondent. We'll set aside and remand.
So the notice was not required because they were challenging the order of review by the Bihar Land Tribunal. Now the act itself bars any review by the Land Tribunal, my lord.
So it is for him. If you are deleting that, you are not claiming anything against the respondent.
They are necessary part.
Huh?
We are claiming against them.
You are claiming. Then we will set aside and remand the matter to the single judge.
Very well.
State of In the instant NPA, the appellants have assigned the order dated 25/4/2019, passed in CWJC 8623 of 2019. So, respondent number 6 to 9?
6 to 9, Lord.
6 to 9. Who is appearing for 10?
He is dead, Lord. Her name has been deleted by the last order.
9 were added as a respondent. However, Lord Single Judge has not issued notice and proceeded to decide CWJC 8623 of 2019. So, therefore, it is a case for remand to the Learned Single Judge, before the Learned Single Judge, for the reasons that respondents 6 to 9 were required to be heard in the writ petition. Accordingly, the order of the Learned Single Judge dated 25/4/2019, passed in CWJC 8623 of 2019, stands set aside. Matter is remanded to the Learned Single Judge. No, the CWJC 8623 of 2019 stands restored. Registry is hereby directed to this the CWJC 8623 of 2019 before the roster will.
Right.
Serial number 29, Kundan Kumasi versus the Indian Railways for the petitioner regarding the Patna.
May I please the Lordships? Lordships, while order dated 23/3/2023, Lordships have asked me a query that whether the license is transferable or not. Lordship, may kindly peruse order dated 23/3/2023.
What license?
It's Lordship catering license.
Huh?
Catering license.
Catering
license granted by IRCTC. Lordship, in this regard, Lordship,
where is the agreement between the license holder and the respondent insofar as running the catering?
Lordship, they have issued me an Annexure 1. This is the allotment later, Lordship.
Where is the agreement?
Agreement has not been entered.
Where is the question of allotment of letter?
Lordship, pursuant to the tender, Lordship, I have applied and I have been selected. Thereafter, this offer letter has been given to me. And renewal is at Annexure 2, Lordship, for 5 years.
Renewal?
Renewal of the license is for 2 years, 5 years, that Annexure 2 at page 27. It is with respect to Lordship 1/1/1998 to till 31/12/2002 for 5 years. Thereafter, Lordship, again for 5 years by Annexure 3, that is.
What is the authentication of page 26?
26. Lordship, this is catering policy 1992.
Huh?
This is page 26 is with respect, Lordship.
No, where is the entire document?
Lordship, I have annexed the abstract only, Lordship.
Huh?
I have annexed the abstract only, Lordship, which says transfer of license in the event of death. This is catering policy 1992. The latest policy is Lordship catering policy 2017, which is annexed at Annexure 5. That is complete, Lordship.
Annexure 6 is 13.
License was granted in whose name?
My father's name, Lordship.
What is his name and what is the date of license?
Lordship, it has been allotted in the 1998, Lordship, for 1 year. Quite Annexure 1. Yes, Lordship.
There is no date.
Lordship, date is. Lordship, date is not a specific Lordship, but in para 4 Lordship I have stated that.
Where do you get right?
Lordship.
Huh? To transfer the license stood in the deceased name.
Lordship.
Where do you get that? Right?
Right, Lordship. Annexure clause 18, Lordship. Clause 18, page 48, Lordship, which is a part of catering policy 2017. It starts from, Lordship, page 33. Relevant Lordship will find at page 48. This is catering policy 2017. I am inviting Lordship attention to clause 18 at page 48. Transfer of license to legal heirs would be allowed only in the event of death of the original licensee. The license shall be transferred in the name of legal heirs for the unexpired period of the contract as per general conditions of the contract of railways. No subletting will be allowed.
Now show the material that the license was in vogue as on the date of death of the...
Lordship, I am saying. Yes, Lordship, I am coming. Lordship, earlier, Lordship, I have approached this Honorable Court via Annexure 7. Lordship will find it is a judgment of the division bench. Lordship will find my name as applicant number 4, page 7, Annexure 7, page 53, Lordship.
What is the license period in respect of deceased Revati Ranjan Prasad?
Lordship, I am running this premise, Lordship, for the last 22 years. Sometimes they have renewed it, sometimes they have not renewed, but they have accepted the money, Lordship, till Lordship December 2019. Till December 2019. Before that, Lordship, I have approached earlier they were not renewing my license. Therefore, Lordship, I have approached this.
Legally continuing, you want us to...
No, Lordship. The division bench has allowed my case, Lordship, and division director has given direction to renew my license in my favor. This is judgment, Lordship.
If there is already a direction, you file contempt.
Lordship, thereafter they have fresh, since your father has died, so therefore I am not going to renew it. So therefore I filed fresh writ, Lordship. And Lordship, this Annexure 7.
Last order was in whose favor?
My favor.
Sons.
No, my father was alive at that time.
It was...
Appellant number 4.
They renewed that license in pursuant to that order.
Lordship, they have to renew, but they didn't renew. And what they did in the meanwhile, Lordship, my father died and they said, now your father is no more, so therefore I am not going to extend. Lordship, one catch is there, Lordship. Annexure 7 is...
Your father died on what date?
Lordship, 22nd October 18.
19. Your death certificate is...
2nd October?
18.
22nd October 19.
2nd of October 19. Paragraph 17.
Yes, Lordship. 22nd October 19.
The license was up to what date?
Lordship, they have accepted money till December 19.
You are not answering the court.
Lordship.
Court is asking you, license was in vogue till what date?
Lordship, they renewed the license till 2005 and thereafter they have not renewed it.
Your father has also lost right.
Lordship, what I am
not renewed.
Lordship, what I am trying to submit to Lordship is, Lordship, earlier I approached this court against non-renewal. I lost my writ petition, Lordship. Thereafter, I went in appeal, Lordship, and the appellate court, in a very detailed judgment, Lordship, they have directed.
Why contempt, sir? Why all this?
Lordship, Lordship, Annexure 7 is also under challenge to the apex court, Lordship, and there is a stay. So that is the reason, Lordship, I am not filing contempt.
Take up this matter to Supreme Court.
So, Lordship, 12th.
Otherwise, you will declare that you have no right. Because when your father was alive, license has already expired and it was...
License has not expired. They have directed me.
I am asking you more than 3 occasions. What was the document?
They have, yes, Lordship. Annexure 3, Lordship, may kindly see.
License was in force till what date, sir?
Yes, Lordship. I am coming. Till 31st December 19.
Where is that?
Yes, Lordship. Annexure 3. Annexure 3 is there later, Lordship.
Page number?
Page number 28. No. Annexure 4, Lordship. Annexure 4, page 29.
This is UCO Bank.
Yes, Lordship.
UCO Bank will not give license.
No, they have accepted this money, Lordship.
Acceptance of money is different, mister. Where is the license renewal?
They directed me to deposit this.
Deposit is different.
There is no license, Lordship. They have not renewed in terms.
Therefore, you don't have right. At the best, you are entitled to refund of 23,014.
Lordship.
25,104.
Wait a minute, Lordship. Lordship, may kindly come to Annex 7, Lordship.
Sir, counsel, you don't have right.
Lordship, may I tell Lordship that this matter may be kept after 12th, after this on.
Why? Today is not an auspicious day for you?
No, 12th is the date fixed for SLP, in which stay has been granted. Annex 7 has been stayed by the Apex Court. So 12th is the final date, 12th May. And this order is in my favor. Lordship may kindly have a...
That is the reason we are saying if it is in your favor, file contempt. On one hand, you say that it has been stayed.
Lordship, with this liberty, Lordship, I will file contempt.
And counsel, sir, after arguing for some time, this time, release this matter after 4 weeks.
All right.
Serial number 30 is adjourned for 2 weeks. Serial number 31 is adjourned for 3 weeks. Serial number 32 is adjourned for 3 weeks for rejoinder. Serial number 33 is adjourned for 4 weeks for rejoinder. Serial number 34, Mrs. Asian Construction versus the State of Bihar for the solicitors to Avnish Kumar.
Good. So, in pursuance of my lord last order, the executive engineer, the executive officer has filed his affidavit. My lord, may kindly see the last order passed by your lordship.
What is the affidavit file?
Lords, he said that they had submitted documents regarding satisfying the conditions contemplated under paragraph
What is the date of affidavit?
It was given to members on 10/4/2023. 12/4/2023.
Please, Lords, in pursuance to the last of Lordship, I have filed counter today only. I am permitted to submit hard copy.
How it will be listed?
I am sorry, Lordship. Since yesterday the portal was not working, Lordship. That is why yesterday I could not file in evening, Lordship. In morning today I filed.
This is hereby directed to that day.
Physical copy with my friend.
Personal affidavit stated to have been filed on behalf of respondents 7 and 8. Sorry, on behalf of respondents. Next week.
Yes, sir, I am appearing on behalf of respondent number 8.
Earlier you were not there.
I was.
Who is there? Respondent 8.
Obliged, Lordship.
Number 35, 2015 versus the State of Bihar for the petitioners, Speaker Bihar Salman.
Wait, please. My lord, the petitioner in this case, my lord had participated in auction sale on the basis of my lord, the catalogue that was displayed online by the annexure number 1, my lord, page number 21. And the bid with respect to lot number 9 was finally, my lord, approved and accepted on 3/9/2022. That is, my lord, that is at page number, your lordship, I can see, as 43, your lordship. And to begin with, my lord, may kindly draw attention, what was the item that was displayed in the catalogue, your lordship? That the bid with respect to lot number 9 that was my lord.
Agreement was entered.
Agreement, my lord, actually I participated, this was online, my lord. Live auction was there. There was no, my lord, as per the condition, I deposited 75.
Order was issued.
No, my lord, work order had not been issued, only.
How are you entitled for writ of mandamus?
Actually, I was the
Where is
purchaser.
your right, sir? Where is your right so as to seek a writ of mandamus, that too in a contract matter?
My lord, without any notice, without any intimation, they have simply bring a.
First of all, where do you get your right? From what document you have established your right?
My bid had finally been accepted by them, that the contract had now got concluded.
Have they issued work order? You filed a suit for damages against them.
My lord, the money that they have taken, my.
All right, sir, file a suit for damages. You are not entitled for writ of mandamus.
They at least, my lord, give direction, my lord, give direction, them that return my money at least.
First of all, writ itself is not maintainable. So for us seeking writ of mandamus, that too in a case where a work order has not been issued, is taken.
My lord, my lord, actually, I happens to be the purchaser of the item, my lord.
Sir, whatever it may be, sir, where is your right? Please understand, under Article 226, for issuance of writ of mandamus, two instruments are mandatory. One is legal, another is demand before the authority. Take note, in the instant, sir has prayed for the following relief. Prima facie, the present sir has not established that he had a statutory and legal right offered by demand before the competent authority. Accordingly,
लगता है पकड़ा जाएगा 47 पुरस्कार साहब, अभी बच गया था, एक सप्ताह का टाइम हो गया।
कोई अपील है, बाकी लोग को दे दिए हैं, ये लोग तो ले जाते
47 नहीं ना एडजॉर्न है।
Now the notified case, serial number 1, CWC 5459 of 2023 for the petitioners Ms. Ankita Kumari.
Pursuant to the tender notice, my lord, annexure 1, my lord, we have submitted our application. Tender is, my lord, for procurement of, for supply of elastic rail clips, my lord. Elastic rail clip. In Indian Railway, my lord, in the track, elastic rail clips, we are the manufacturer of elastic rail clip. RDSO, Rashtriya Ispat Nigam Limited, my lord, approved, my lord, the firm. What happened, my lord, in this case, my lord, that the tender notice, page 14, if my lord will see, page 14, clause 3, in the tender notice, the certificate from the statutory auditor, third line, my lord, the certificate from statutory auditor or cost,
page 14.
Page 14, my lord, clause 3.
Clause 3 is as estimated.
As estimated, my lord, outline. As the estimated value of the tender is more than 10 crore, therefore, as per Government of India Make in India policy, it is mandatory that the bidder must upload a certificate from the statutory auditor or cost auditor of the company. In the case of the companies, or from a practicing cost accountant or practicing chartered accountant in respect of supplies other than companies, giving the percentage of local control for the brief, with the brief description of tenderer item as offered and to be supplied by them. The necessary certificate of local content uploaded must be signed with UDIN. Any offer without the certificate indicating the required information as mentioned shall make the offer ineligible for consideration in this tender, as this item has been identified by the railway as to be procured from class 1 local supplier, and so offer shall be summarily rejected without any back references. Now, my lord, the column remark, the just confirmation required, yes. Confirmation required, yes. This is the second column. Third, remarks allowed, yes. And the third column is, fourth column is document uploading, not allowed. So I am not allowed to upload the document of chartered accountant, my lord. The corrigendum, my lord, subsequently corrigendum was issued by annexure 3, page 21. The bottom part, if my lord will see, uploading, my lord, that was allowed, but it was optional. The last column, my lord, document upload, existing value not allowed, and uploading, my lord, allowed, but that is optional. So I did not upload.
What is the date of corrigendum?
Corrigendum date is, my lord, 13/2/2023.
Yes.
My lord, then the communication, my lord, communication to me, my lord, next page, annexure 4, page 22. It was opened and I was found not suitable for ERA for non-submission of CA certificate, Chartered Accountant certificate. So I cannot submit, my lord, because it was not allowed earlier. And subsequently by corrigendum, it was not mandatory. It was optional. And on 10th April 2023, this was the communication day before yesterday, my lord. And today, my lord, on 13/4/2023, today, my lord, just, my lord, it was refreshed, and 17th is the date fixed, my lord, for closing of the
Yes, sir. Your Lordships, just now it was filed yesterday, we've just got it. And I cannot say till I get instructions, Your Lordship. So far as he says, Your Lordships,
by next week, we'll take further financial bid till next date of hearing.
Monday. On Monday we cannot get instructions.
And this is incomplete. But यहाँ देखिए, यहाँ कुछ क्लिक करके पूरा भराएगा. आप अभी जो दिए हैं. And जो सर्विस के लिए बोल रहे हैं कि मेंशन करें अर्जेंट मैटर. आज ना.
This paper also, Your Lordships, appears to be incomplete. There's something to be filled up here. I don't know what is happening. I cannot, Your Lordships.
But for want of time, 17th is the.
I know that
you have a holidays.
That he has said because in the meantime it is. Subject to result, Your Lordships, may.
Huh?
Subject to Your Lordships.
Result of this. नहीं. Subject to the result in this application, that financial bid will be finalized.
Your Lordships may permit the financial bid to go on subject to the result of this.
No. Nothing will happen 2-3 days.
No, we are in touch with them.
We are in touch with them on telephone. We are in touch with them on telephone. I have sent them an email copy. They said just give us time to go through it and we'll get back to you. So, Your Lordships, Monday. Let it be on Monday at 10:30. Let it be on Monday at 10:30. And then if we have some information, otherwise Your Lordships may pass the order at that time.
Tomorrow is also national holiday. Right?
Tomorrow is also because
national
tomorrow, day after all holidays. That's why that is the difficulty. Otherwise, tomorrow morning I would have got the instruction.
17th at what time? The financial
time दिया है. क्या बोलिए?
Yes. 12. At 12. Just now it is uploaded, my lord.
So at 10:30, Your Lordships may hear if there is something.
And counsel for the respondents are hereby directed to get positive instruction in the light of corrigendum dated 13/2/2023 insofar as documents uploading is concerned. Earlier it is not allowed, whereas the corrigendum it is indicated that allowed within bracket optional.
21, 22.
The word optional empowers the concerned bidding party have option choice of uploading and in not uploading. This matter on 17th. Monday it will come.
First case will
mention at 10:30.
You'll also.
In Northern Railway, my lord, the confusion arose, then the railway requested to rectify the defect. By Annexure 5, my lord, I have annexed, because I am the regular supplier, manufacturer of the rail clips. This confusion arose, then I was requested by the railway to rectify, but this time, my lord, I am not being allowed to.
Whatever, if I could have a copy of the order, that would.
Of it is order.
If it is of this order shall be provided to the learned counsel for the respondent. That.
Okay.
My lord, in case, my lord, it is opened at 10, my lord, then.
12 o'clock is the time given, how can they open it before that? If they are given 12 o'clock time, they can't open before that.
At least from till date, my lord.
We will circumstances warrant, we will postpone the timing from 12:30 to 4 o'clock.
Oblige.
Serial number 26, the Commissioner versus Sri Niranjan Parmi for the petitioner, Sri Siddharth Prasad.
Lordships, this is a case where for sexual harassment of a student, the teacher was proceeded against your Lordships. Now, the matter came up before the Central Administrative Tribunal, your Lordships. The administrative member upheld the order of the disciplinary authority. The judicial member disagreed. Matter was referred to the third member. Your Lordships, I be permitted to just place the order of the third member. That is para 11 onwards. That gives the gist of the whole case, your Lordships. Internal page 9, your Lordship, of the order. Before I proceed further, I fully agree with both the honourable members with respect to the conclusion that the Commissioner NBS, the highest authority in the management of the institution, has concluded that the regular inquiry needs to be dispensed with for the reasons recorded by him in support of his decision with respect to not conduct an inquiry under the rules and also post the facts before the Minister, Human Resource Department, Government of India in that behalf. Without hesitation, no fault can be attributed to the respondents with respect to the dispensing of the full-fledged inquiry. Now here I will pause, your Lordships, and submit that all three agree on this one point. Your Lordship, then
on the point that no inquiry is required.
Yes, that is under the circular of 1993, your Lordships. Circular dated, your Lordships, 2012-1990 circular, which empowers that in cases where it is not appropriate for a full inquiry to be held, where the victim will be cross-examined and things like that, then the inquiry may be dispensed with, and if he is prima facie found to have committed the offence, he can be punished. And that has been upheld by the Honourable Supreme Court.
Then the petitioners have followed which procedure?
They have followed that procedure laid down in the 2012-1993 circular, your Lordship.
Circular or act? Some act is there, no?
Act is...
Sexual Harassment Act.
That act is there, but for the Navodaya Vidyalaya Samiti...
No, these employees are governed by which rules? Regulation.
By the CCS rules, your Lordship. Yes.
CCS rules. Was it 14.3?
Lordships.
What do you welcome?
Lordships,
TGT.
Yeah?
TGT. Trained graduate teacher.
He is a trained graduate teacher, your Lordships.
Rule 14.3C, something has been incorporated. respect of sexual harassment matters.
Your Lordships, Your Lordships, at page 7 is the notification, Your Lordships. Annexure 15. It says it has further been decided with the approval of the executive committee that the relevant...
No, rule, have you seen it? Seen the rule?
Just taking the book, Your Lordships.
Read 14.2, proviso. Up to date rules.
Where it is proposed to hold an inquiry against...
No, that is not the provided that where there is a complaint of sexual harassment within the meaning of Rule 3C of the Central Civil Conduct Rules. The complaints committee established on each ministry or department or office for inquiry into such complaints shall be deemed to be the inquiring authority appointed by the disciplinary authority for the purpose of these rules, and the complaints committee shall hold, if a separate procedure has not been prescribed for the complaints committee for holding the inquiry into the complaints of sexual harassment, the inquiry as far as practicable in accordance with the procedure laid down in these rules.
Your Lordships. Your Lordships, I think...
One more rule is there, dispensation. I don't know whether you know that provision or not. In the very same CCA rules, there is a provision. Are you sure that this Navodaya employees are bound by this CCA rule?
That we have stated on affidavit also.
This other notification is prior to Vishakha case.
One thing that I am lacking here, that which Your Lordship allow me to permit. Written statement filed before the learned tribunal. On the basis the learned tribunal has disposed of the original application. Is not on part of record. Summary trial was conducted. Summary trial was conducted. Summary report came. The matter was placed before the competent authority commissioner. Commissioner, while ordered at the last page of the written statement, 21st December 17, turned down the report, trial committee report, directed them to re-inquiry. No re-inquiry was conducted.
Your Lordships, may just permit me to complete the impugned order, Your Lordships.
No, further, where is the provision for dispensation of inquiry?
Your Lordships, that is the 1993 rule.
No, 1993 circular, you said.
Circular, sorry.
Circular will not override rule. Rule is 14.3C. 14.2 read with conduct rules. Where is the conduct rules? Central government conduct rules. इधर है. इसका separate है. Central government. Central Civil Services within the Conduct Rules 1964. Proviso to Rule 14. You are required to comply this rule only, provided if you have any other procedure rules.
Your Lordships, what they have done, I'm just informing Your Lordships, what they have done is they have followed this notification, upheld by the Supreme Court.
We'll adjourn this matter next week. In the meanwhile, you get instruction whether how do they work the 14(2) proviso. One thing. Another thing, the Sexual Harassment Act has whether that has been adopted by the central government or not.
That I'll take it.
If that has been adopted, then you can dispense inquiry under this, and you can follow that procedure laid down therein. And the act read with the rules. They have also framed rules.
Yes. But in that also, Your Lordship, the appeal is provided as per CCS. But Your Lordship, I was going to Your Lordship make another submission. Seeing this, Your Lordships, I don't know if Your Lordships would consider it appropriate to remit the matter back.
For what purpose?
For them to inquire afresh. For them to go into it afresh. Because if Your Lordship sees para 17 of the third member,
this is the order.
That is
the order by the learned tribunal.
That is the order of the learned tribunal, paragraph 17. If Your Lordship sees, Your Lordships may like to consider it. And that may end this. In view of the above observations, I agree with the view taken by the Honorable Member J. However, to cure the deficit.
From the stage of summary trial is held under which provision?
Summary trial is held under that 93 notification, which has been upheld by the Supreme Court.
93 order will not override this rule.
That I understand, you know, because this is a later amendment.
That's the reason you get instruction.
I'll get it.
Let us not have confusion.
Instructions on two counts, whether the
14(2) proviso is required to be has been complied or not. One thing. Second thing is Sexual Harassment Act so and so and read with rules have been adopted by the central government while amending CCA rules.
Your Lordship may give 2 weeks.
Writ petition is by the Union of India dash Navodaya
Vidyalaya Samiti. Navodaya Vidyalaya Samiti.
Navodaya Vidyalaya Samiti. Twist of respondent was subjected to some inquiry on the allegation that he was alleged to have involved in some sexual harassment to a girl student resulted in termination service, and it was subject matter of litigation before the CAD. So, next for learn counsel for the is hereby directed to apprise this court as to was there any compliance proviso to sub rule 2 of rule 14 of CCS within bracket CCA rules 1965 or not. Further, the light of so and so act, sexual harassment act, so and so, read with the rules read therein have been adopted by the central government or petitioner Navodaya so and so Samiti or not, in order to examine whether the petitioners have followed the relevant rules and regulations or not. This matter after 2 weeks.
Okay.
I'm sorry, my lord, for the inconvenience, my lord.
You want to withdraw?
No, my lord, it will start from 10 o'clock, my lord, not 12. My lord.
12 o'clock is the
10
time.
o'clock, my lord, is the time for starting the meet, my lord. From 10 o'clock, Lord, it will start.
So, Lordship, some cursory instructions I received just now, but because I was communicating to them, he said in the description it was not allowed, then it was allowed, and it was in the bracket is optional because of the system. He could have uploaded it.
Correct, but you have given option, no?
No, that's why
you should have a positive saying that they should allowed.
No, but description says it's mandatory.
The corrigendum
is the description.
Within bracket, what is meant by within bracket option?
He said that is because that is for the system.
Sir?
Yes, because in uploading.
But you have not mentioned that.
He says that.
How to understand within bracket optional?
The persons who do e-bidding and they know about it, that the system will say it is optional, but they have to do it because the description says it's mandatory.
Sir, where do you get that definition of optional?
That's right. That's why I'm
so we will grant interim order.
What subject to your lordship's consideration? I'm not. Let it be it should be subject to the outcome of this result of this writ application. Let
no, otherwise you consider his case also. And subject to outcome of this
if your lordships find his writ application to be allowed, then the whole of my bidding will go.
No, sir, consider the petitioner name also for the financial bid and keep it in sealed cover or something.
Monday we will file.
It doesn't seem to be. Then
let his technical bid has been.
But then he will see a certificate to them.
Your Lordships, he can send his CA certificate now also.
Subject to outcome of writ petition?
It will be accepted subject to outcome of the writ application. And they will consider that your Lordships may order.
You have taken the dictation. At this stage, we notice that financial bid is likely to be opened at 10 o'clock on 17/4/2000. Therefore, in the interest of rendering justice to the party, petitioner is hereby directed to furnish whatever the demanded documents through online or furnishing a hard copy. If such material is furnished, the same shall be considered at the time of opening financial bid The petitioner's claim in the financial bid is subject to result of the president. We'll give you a date, a further date.
Yes, 2 weeks will also be.
2 weeks. In the meanwhile, concerned respondent is hereby directed to file counter affidavit clarifying the aforementioned issue.
आज खुला रहेगा ना, कल से बंद हो जाएगा.
You can go and type now. Send some.
File notify.
रहेंगे आप बता दीजिए.
Serial number 37, Ram Iqbal Rai versus India for the petitioner Sri Vijay.
No, the matter, my lord, in which contract work allotted to the petitioner has been cancelled on the ground that second installment has not been paid. Your lordship, my lord, at the first instance asked me also as to whether there was any provision. I replied, your lordship, that no, there was no such provision. Rather, whatever provision is there, I have annexed, my lord, and your lordship.
Condition for
guideline is
second license fee is required to be deposited within so and so time.
Within 15. So there is nothing so.
Then that clause, the second license fee.
Then I replied that there is nothing so, and so, my lord, I have guideline. I have annexed the guideline.
You did not deposit.
No, second installment I have not deposited further.
No, all right, sir, you are not deposited, but were you required to be deposited or not?
Yes, I am required to deposit.
Where is that provision?
Yes, my lord. That is, my lord, Annexure 1 itself.
Where is the clause?
Work order, paragraph number 2. Further, you have deposited the first installment of quarterly license fee for rupees so and so, and 45, including so and so, through portal, award, bid sheet, as well as is to be deposited contract local quarterly. Now, Lord, I wanted to place before Lordship the.
Mr. Respondent Counsel, where is the requirement of depositing second installment within how many days? Where is such a condition is stipulated? Says that first installment.
Lord, your Lordship's query, I have annexed, my Lord, Annexure 5 with a second supplementary affidavit. That is, my Lord, standard conditions of the contract. Second supplementary affidavit, page 6, Annexure 5. And relevant is page 13, clause 18.1. Railway shall reserve the right to terminate contract as private measure without any notice at any time in case of violation of any term and conditions of the contract or due any other serious limited to violation of the Railway Act. That is not the allegation, my lord. And it is...
Page number?
page number 13, 1-3 of the second supplementary affidavit, my lord. Because your lordship asked me, my lord, so I have annexed whatever against me also.
17.2. 17.2. By railway administration, railways shall have the right to terminate the contract agreement without any financial repercussion.
Sir, where is the demand or condition that second installment is required to be deposited by him by what date and all?
I have to seek instruction on this matter because
Counsel for the respondents are hereby directed to file counter affidavit before the next date of hearing. List of 2 weeks.
3 weeks कर दिया जाए.
3 weeks.
In the meanwhile, they should not allot to another person by, they have issued tender.
We are not able to convince this court. What we can do?
Yes, well, that is nothing so, and notice is required. Unless notice, 30 days notice is there.
They have mentioned in the condition, no notice without assigning reason, contract can be terminated. Have you challenged that condition?
No, because that is with respect to if I have violated any terms and conditions. Otherwise, I have not. And Annexure 5, my lord.
Annexure 1, there is an indication. First installment is this amount. Where is the second installment?
There is nothing, sir. That's why I have prayed, my lord. And so, my lord, Annexure 5, my lord, condition number 17.2 says about notice.
What is the date of cancellation of tender?
Date of cancellation, my lord, is
contract
16/1/23. 1/23, 16th January 23.
Have they re-advertised, reissued the tender?
Yes, my lord. That is, my lord, on 1/3/23.
1/3/23.
Have you participated?
No.
Why?
Because it is just now a tender has been issued, I have not participated.
Then how can we impose condition?
That I have annexed, my lord.
Correct, but you are not participated. Sorry, yes.
Still, that has not been finalized, my lord.
Maybe, sir. Certain rights are created. You should have participated.
No, I'm sorry. It has only been notified. Till date, it has not been done any auction or something.
You should have participated. Subject to outcome of this.
No, till date, it has not been done.
Huh?
Till date, it has not been auctioned.
No, all right. Then no, where is the question of interim order?
They may, my lord, because...
Sorry, no. If you have participated, definitely we would have granted interim order.
No, still I have not because it is not...
He has not participated in that.
Yes. On next case.
Serial number 38 is adjourned for 3 weeks. Serial number 39, Chandra Han Upadhyay versus the Union of India for Sri Munna Prasad.
May please. In this case, the petitioner has challenged the part of the order passed by the learned tribunal regarding denial of interest portion. The case of the petitioner is Millar. The petitioner has superannuated on 30th June 2018.
Huh?
He is superannuated on 30th June 2018. The post of senior store issuer, class 3 post. In pay scale of rupees, basic pay of rupees 43,500. After his superannuation, the authority has issued impugned order on 2nd November 18 and 4th December 18. Without any so-called notice, his entire pensionary benefit has been fixed to the post of class 4 post. The petitioner challenged that order before the learned tribunal. The learned tribunal has allowed Millar on 29/9/21. 9/21. The authority, after passing the impugned order, Millar fixed the entire pensionary benefit to the post of class 4 and rupees 11,41,125 has been recovered from retirement dues against overpayment. The tribunal has allowed on 29/9/21. The railway has assailed this order before this honorable court, and this honorable court has upheld the order of the learned tribunal on 10th August 2022 by the annexure 2. Thereafter, the authority has paid, make the payment, but the tribunal has not granted interest on the retirement dues. That's why the petitioner is before Lordship.
Where is your original application?
Original application is page 55 onwards. And relief is
55.
Page 55, running page 55. Original application starts from page 55 and relief is at page 81. I get all the amounts, Milad, after 4 years.
Substantial post, he retired as a Group D post, Your Lordship. He retired as a substantial post as Group D post. Later on, he got the promotion as a Group C post as on ad hoc basis, Your Lordship. The CAT allowed the application, Lordship.
No, question is whether is he entitled to...
For interest, the dispute is only of the interest part, Your Lordship. Whether the interest should be given by the railway or not, Your Lordship. Here, the counter affidavit has gone for vetting, Your Lordship, but the statement of fact says that there is no delay on the part of the railway, Lordship, because the railway fixed the retirement dues as Group D post, Your Lordship. Later on, the Group D post, Your Lordship.
Instead of Group C.
Instead of Group C, Your Lordship. Later on, CAT allowed the case, Your Lordship.
As on the date of retirement,
he was as an officiating Group C.
2018, he was holding which post?
As a super Group C post, Your Lordship.
If it is a Group C, how can you settle his retired dues in Group D?
So the settlement has been done, Your Lordship. The CAT allowed the case, Your Lordship.
Sir, have you paid all retired benefits on 30th June 2008 reference to Group C post or
Group D post, Your Lordship?
Group D.
Why? Because he was not he was officiating as a Group C post, Your Lordship. Substantial post was Group D, Your Lordship.
No, official. Then what is the mode of appointing him to Group C?
That is the Your Lordship in...
You are given ad hoc promotion.
Ad hoc promotion.
In 1990.
1990.
On 1st July 1990.
He got
another promotion on 20th February 1996.
20th February?
1996. Senior store steward. And thereafter he retired. Senior store steward.
Senior store.
Senior?
Store. Bhandar.
Senior store?
Steward. Grade pay of rupees 24.
So he retired as a senior store issuer?
Yes.
Then pay scale pension has not been settled with reference to senior store issuer?
Sir, after my retirement, they have issued the impugned order fixing my entire pension benefit to the post of class 4 Khalasi. That was SL before the learned team.
By virtue of CAT order, you got the relief with reference to senior store.
Milan. After September 22.
There is dispute of only that is interest part, Your Lordship.
That is
interest part, Your Lordship. The
railway authorities have committed blunder. When he retired while holding the post of senior store issuer, how can you fix his retirement benefits in Group D?
Got substantial post as Group D post on 1183, Your Lordship.
Has he been granted increment from time to time?
Yes.
There is a...
And he has been granted TBA also?
Everything.
For indulgence is required, Lordship, because the counter affidavit has gone for vetting, Your Lordship.
Counter affidavit?
Has gone for vetting, Your Lordship, for this case, Your Lordship.
You want to file a counter affidavit?
Lordship.
Then we'll impose exemplary cost also. Be ready for that. One issue involved in the present list is whether petitioner is entitled to interest on belated settlement of retired dues. So, evident that the petitioner, as on the date of his retirement on 30th June 2018, he was holding the post of senior store issuer. Please stop. Therefore, last pay drawn, a retired post is required to be taken note of for the purpose of fixation of retired benefits, including the fixation of pension. So, on the other hand, respondents have implemented the orders of the CAD, accepting the fact that the petitioner has attained years of superannuation and retired from service while holding the post of senior store issuer. In this backdrop, due to error committed by the railway authorities, the petitioner shall not be penalized in not settling the petitioner's retired dues within the reasonable period of time from the date of his retirement on 30th June 2018. On the other hand, they proceeded to fix the petitioner's pension with reference to Group D post.
Pension and all other benefits.
Such arrangement was made on the presumption that the petitioner was holding ad hoc promotion against a Group C post on 1/7/1990, and further he has earned promotion on 20th February 1996 to the post of a senior store issuer. If the petitioner is not entitled to hold the post of a Group C and senior store issuer as on 1/7/1990 and 20th February 1996 respectively, in such an event, they could have resorted action in reverting him to his term. As on 30th June 2018, there was no action of reverting the petitioner to hold the post of Group D so as to settle his retired dues against the Group D post. Prima facie, the petitioner has made out a case so far as the granting interest. Student counsel for the respondent seeks time to release this matter after 2 weeks as the last chance.
Serial number 40, Subhash Kumar Shukla versus the Union of India for the petitioner Krishna Kumar.
May I please, Your Excellency? Notes, this application is against the Central Administrative Tribunal dated 5th of September 22. The matter in short is, my lords, that this pertains to holding of examination for promotion from the senior accountant to assistant accounts officers in the cadre of Indian Post and Telecommunications Accounts and Finance Service Group B. A total of 1,010 posts had been advertised, out of which 777 were in the general category. We all belong to the general category. Now, my lords, we participated in the examination. The merit list was prepared. That was in October 2018, in which only 949 results were published, holding back some posts, and out of which 58 are belonging to the general category. My lords, we went to the Central Administrative Tribunal, and during that time, my lords, a policy decision had been taken by the respondents, my lords. I take your lordships, my lords, from that, my lords. If your lordships would be kind enough to come to my lords, page 134, annexure 7. And the relevant part, my lords, at page 138. My lords, at 138, my lords, there are 5 items out of which on which the policy decision had been taken, in which point number 1 and 4 would be important. My lords, at page 138, 5 items had been decided by the department. Number 1, as there was a backup of candidates from the general category who had a...
Not readable.
My lords, in the impugned order also it is quoted. If your lordship should permit, I will take your...
Highlighter, and thereafter it was, Xerox copy was taken.
My lords, that mistake is there, my lords. So that is there in the impugned order also. It is contained, my lords. So from that, if your lordship should permit, I will place
The
that.
question is, how many vacancies were required to be?
Now 58
is required to be identified.
Well, 58, that is the admitted position. At 1010, they had published results of 949. The main part is the clause 4. If your lordship, in that at page 138, which your lordships will see, if that is readable. As per the...
Not readable.
My lords, kindly come to the impugned order itself, my lords, at page 40 and 41. That is quoted, fully quoted in the impugned order. At page 40 and 41. Page 40, my lords, at the bottom, clause 1.
There is no pagination in so far as the CAT order. Give the paragraph number.
Internal page 4 of this CAT impugned order, my lords. Lordships, in the lower half, 1, as there are a backup of candidates from the general category who had achieved the 40% marks but could not make to the merit list, a waiting list of all those may be published / issued for filling up of the resultant vacancies in assistant accounts officers cadre till the next examination is conducted. Then next page, my lords, clause 4. That was also a policy decision. As per the recruitment rules in vogue, the recruitment to assistant accounts officer cadre is through LDC, Limited Departmental Competitive Examination. The waiting list so prepared as above may be used to fill up all the resultant vacancies arising after 2018 till the conducting of the next LDC or outcome of the court case filed for exhaustion or the merit list, whichever is earlier, as a special measure in dispensation of, my lord. Then pursuant to this, my lords, the OA application which was there, kindly see the order that had been passed by the OA, the CAT, my lords, that is annexure P9 at page 147. The earlier one. At page 147, my lords. It is only 2 pages order. I will request my lords to kindly go through. Lordships, these petitioners were there in the OA application, the bottom portion onwards. It is the MA number so and so preferred by
147 is something
annexure P9. No. Lordships, the last 2 lines. It is the MA of number 166 of 2020 preferred by the applicants of OA, which is listed for hearing today. The prayer made in the MA is, your lordships may graciously be pleased to command and direct the respondents' authorities to allow the applicants their appointments on promotion to assistant accounts officer in terms of policy decision as contained in annexure so and so and its implementation as ordered to SC/ST candidates by office order dated so and so as contained in annexure so and so at earliest without any further delay. Heard. It is inquired from learned counsel that adjudication of the prayer in its present...
Furnish a typed copy. Not able to.
Lords. Heard at page 148. Heard para 2. Heard it is inquired from the learned counsel that adjudication of the prayer in its present made in MA would not tantamount to disposal of the OA also, and learned counsel submits that in fact applicants did appear in LCDE for the post of AAO were declared successful in the written examination, but they being aggrieved and hurt by non-accommodating of them against the non-filled and left out vacancy of AAO did prefer the OA. that according to respondents, applicants were not coming into the merits for appointment to the extent of available posts, and thus they were not appointed and were kept in waiting list. But now, having taken note of policy, which is annexure so and so of MA, and panel of waitlisted candidates is being prepared for appointment against the remaining vacancies, and applicants are hopeful that they would be appointed through this panel. He referred to para 21(4) of annexure so and so. Learned Counsel for respondent submits that this OA has become infructuous, hence it may be disposed of. 21(4) of annexure so and so stipulates, as per the RRs in vogue, the recruitment to assistant account officers cadre is through LDCE. The waiting list so prepared as above may be used to fill up all the resultant vacancies arising after 2018 till the conducting of the next LDCE or outcome of this court case filed or exhaustion of the merit list, whichever is earlier, as a special measure or dispensation of. Inviting attention to its text and prayer portion of OA, it is inquired from Learned Counsel that if the respondents has already taken decision for appointment, then whether this OA has not become infructuous. And Learned Counsel fairly answered that the OA has become infructuous, but applicants are apprehending that perhaps they would not be appointed as they have filed the case. He requests that this OA may be disposed of with liberty to applicants to file afresh another OA if they feel aggrieved after implementation of aforesaid policy. In view of the said, OA number so and so becomes. Now they have made a somersault. On their own policy decision, they have turned down, and therefore we approach the court, and in view of that, what the learned tribunal passed the order, my lords, that is worth reading. The tribunal says, even though it was a policy decision, but they had not issued the office memorandum or they had not notified, therefore it will not be applicable. It is on their undertaking, it is on their assurance, it is on their this making it fell to the court, my lords, that it is a policy decision that will be implemented and waiting list will be prepared. So we could have immediately and easily gone through, my lords, but they have made a somersault. That is in the impugned order. Your lordships will kindly come to the impugned order now, my lords. 5 aspects of policy decision, clause 1 and clause 4 very important.
Now, if they are not implementing the vacancies accrued in the year 2018, 1/4/2018 to 31/12/2018, then what those
that is my remedy. If they implement
those vacancies have lapsed.
No.
Then how are they going to fill up?
No, what they have done in 22, they have issued another advertisement in which that backlog of 58 they are counting in this. My grievance is that against that instead of treating it for 2018, which they had promised, now they are taking it as a part of the 2022 fresh vacancies.
No, 2021 vacancies are with reference to what? The vacancies accrued in each year.
The year-wise vacancy position is there. If your lordships would kindly see the notification which they have issued, that is, my lords, annexure 11 at page 151. I'll take your lordships straightway to the vacancy position. My lords may kindly come to.
Oh, where is this notification? 24/3/2021.
My lords. This is annexure P10 at page 150. 10 at 150, 150. And my lords, in this, kindly come to page 162. In 162.
No, these 560 posts were identified from for which period?
Kindly see, my lords, kindly come to the page 162, 2018, the leftover vacancies of 2018 at page 162. 70 posts of 2018, which include 58 of the general category, is there, for which they had made a promise that policy decision is there, that waiting list would be prepared and it would be filled up. Not only that, the policy decision was that even subsequent vacancies, until and unless LDC is held afresh, they will be consumed from that waiting list. Now, instead of, and that our apprehension has come true. We had
your grievance is only to the extent that 2018 vacancies were required to be added.
From exactly.
Added.
This cannot be done. This has to be from 2018 only, for which they had promised. They have taken the policy decision.
Where is that policy decision insofar as inclusion of 2018 vacancies for the purpose of?
This they have notified in 2021. This, your lordships, are this is this 58 which I am showing. This is in continuation of that, my lords, at page 150, which your lordships had seen, and the further notification and except P11, 28, 4, that the breakup they have given. This details.
No, where is the policy decision that 2018 vacancies were required to be notified in 2021?
There is no policy decision on that. The policy decision was earlier, which was before the CAT, that all those vacancies of 2018 will be filled up from that by preparing a waiting list. Now they are backing out from that.
No, waiting list means which waiting list?
Waiting list for 949 only they declared out of 1,000 against 1,010 vacancies. So for the remaining, they promised before the CAT that.
No, if that is the event, you should have filed contempt before the CAT.
Lords, the CAT only we filed this application, my lords, and in this application, what the only issue that the CAT has decided, since that there was no notification, and therefore it cannot be compelled to carry out. That finding is there.
What is the stage of this process of filling up of senior accounts officer? Sorry, assistant accounts officer.
We claim that only is from senior.
Correct, sir. Whether this has been given effect?
No. Only the examination has been held. The results have not yet been.
Sometime we can hardly given or filing contract affidavit. 6 weeks time.
Until then, they should not declare or they should not disturb our claim, my lords.
Sir, viewer.
My lords, otherwise, if they declare the result and they make the appointment, we will have to fight against all those 58 persons also, my lords. I'm not opposing to the
concerned respondents are directed to file their counter affidavit for the state of hearing. The meanwhile, action taken pursuant to the notification dated, which is that notification?
My lords, Annexure 10, that is 24.
Promotion proposal.
No, for which the examination was held pursuant to 28(4).
What examination? LCDE.
LDCE, Limited Department.
LDCE examination, and it's a result, and further any orders to be issued to such of those successful candidates is subject to result of the present petition. The concerned respondent is hereby directed to indicate that proceedings pursuant to LDC-2021 examination is subject to outcome of this writ petition.
Serial number 41, Mehasan versus the state of Bihar for the petition.
May I? Lordships and show cause notice under the Bihar Contractors Registration Rule, Annexure 6, page 73, followed by absolutely non-speaking order of blacklisting for a period of 10 years, and followed by rejection of my appeal.
How sure? Against show cause notice, writ is maintainable?
No, it is one of the prayer because it was beyond jurisdiction and it was not maintainable. It was contrary to the rules.
Who has passed the order?
The order was passed initially by the engineer.
Not initially.
The original order.
Notice letter number 6745 dated 25/9/2020 issued by whom?
It is by the engineer in chief.
Senior in chief.
Lordships, yes.
Not competent.
Yes, he is competent, but so far as my lords is pleased to see the show cause notice, it does not contemplate it under what rules it is being issued, and
submit your explanation.
I submitted my explanation. My lords is pleased to see the last order. Till appeal, my lords, I have lost. My lords were pleased to notice on the last occasion that principal secretary was required to file affidavit as to how his order is a speaking order. Thereafter, my lords, I replied to it. It was not considered and I was blacklisted. Then I filed appeal.
My lord, petitioner has filed the appeal.
Where is the counter affidavit?
My lord, petitioner has filed the appeal, my lord.
Counter affidavit is on record.
On record, my lord, I have a statement.
In which paragraph you have stated that
24.
Memorandum, rejection of memorandum.
24 paragraph I have stated, my lord, petitioner filed the appeal and several charge has been found against this petitioner, my lord. FIR has also been found against.
Sir, appellate authority order is speaking order or not?
Yes, my lord, speaking order.
Sure.
My
It has not even referred to my. It is page number 90. It is page number 96, annexure 11.
96.
Annexure 10 is my appeal, and annexure 11 is the order.
Where is the reference to Shokash notice and his reply?
My lord.
So no, from page 96 you have to point out.
My lord, I have annexed this notice in my counter affidavit at page 67, my lord.
You are not answering. Page number 96 and 97.
My lord.
Take that page number 96 and 97 and point out where is the reference to Shokash notice and his reply, how his reply has been considered.
His reply has been considered, my lord, but not satisfactory, my lord.
You are not able to understand. Appellate authority order, has he considered his reply?
My lord, kindly see my counter affidavit in which it has been mentioned, my lord, it has been...
You can't improve things, sir. Are you aware, Mohinder Singh Gill case?
My lord.
What, my lord?
The order says, the order says that the decision to blacklist was taken by the earlier additional chief secretary, therefore it is okay. It is well drafted appeal, Milords, on the ground of jurisdiction, on the ground of fact that the provisions under which I have been blacklisted, that was not referred in the show cause notice, the rules were not referred in the show cause notice, everything is there, but not even a single line. It is only when I asked for payment and this honorable court directed them to consider my representation, then all these started happening.
That is the reason you should not have approached this court.
Submitted by the petitioner in terms of order subsidiary receiving the so and so. We can't practice it.
And my lords, the appeal also, if my lords is pleased to see annexure 10 page 80 on which this order has been passed. My lords will find annexure 10 page 80. It is my lord 15 pages appeal. Every ground has been summarized. I came to this honorable court against the original adjudication order, then I was relegated for availing this alternate remedy of appeal. Then I filed this appeal, annexure 10 page 80.
Who is the appellate authority?
This additional chief secretary cum principal secretary of the department. And he has filed the affidavit and saying he has not even referred to my appeal. Yes, Annexure 11. He has not even referred to my appeal and he has filed affidavit before the court that yes, I have considered everything.
Counter has been filed.
How many times you are saying counter affidavit is filed, counter affidavit is filed?
Already.
Who is disputing?
My lord.
My lord, please tell us.
It has been cited, my lord, several charges have been found against this petitioner. FIR has also been lodged, my lord. Except
Blacklisting for how many years?
10 years, my lords. And none of the grounds considered. And not there is a charge that I did not use coal tar in the construction work. His Excellency, the President of India, traveled on that road. They constituted a liability committee. They accepted everything, and I purchased the coal tar from them itself, my lords. By way of a demand draft, I have annexed that also. They have not rebutted it, and now they are saying to this lady that you have committed forgery and they lodged FIR. And
Annexure 11 was passed pursuant to 84405 of 2021.
He is confused. Actually, this annexure was passed pursuant to the order by which I was remanded. I was required to file appeal. There were 2 rounds. First, my claim was required to be decided by the principal secretary of the payment. Then I filed. Then the committee was constituted. Then they issued show cause notice. And then he writes that उनके appeal पर विचार किया गया है. He refers to the order and the proceedings for payment, and he decides my appeal. If my lords is pleased to see.
Who has passed the blacklisting order?
It is the engineer in chief.
Against that you preferred appeal?
Yes, against that I preferred appeal. Therefore, he confirms the original order passed by the original adjudicating authority. And if my lords is pleased to see the show cause notice was issued in their para 22, para 22 of the counter affidavit, they say that it is appeal in pursuance to the High Court's order. And now just one more submission.
Petitioner has prayed for the following relief. Which is the tender you have not mentioned?
Tender, my lords. The tender, my lords.
Tender was relating to which?
Yes, I have annexed, my lords. It is, my lords, annexure 1. Annexure 1. No, my lords, annexure 1 of my page 46. His Excellency the President of India's visit to Kahalgaon Vikramshila Agman.
No, sir. What is the title of the work?
Yes, my lords will find annexure, column 1, page 46. It is the repair
You
work.
have not mentioned your synopsis and dates and events. And page 46 is in Hindi.
Yes, my lords. It is, my lords. It is the repair work of, my lords, NH80, kilometer 136. Emergent repair works. Clause paragraph 1, my lords. कार्य का नाम महामहिम राष्ट्रपति के कहलगांव एवं विक्रमशिला आगमन के अवसर पर बाढ़ से क्षतिग्रस्त राष्ट्रीय उच्च पथ संख्या 80 के किलोमीटर 136 के आकस्मिक Yes, because it was not urgent, not notice.
No, what is the work? Where is the title of the work?
Yes, my lords, annexure 1, I am just requesting my lords to go through. Yes. It is kilometer 136, lordship. They here mark the kilometer.
What is this asphalting?
It is repair works. I was to do the repair works on account of the proposed visit of the President of India. Actually, my lords, this national highway was damaged, and lords, His Excellency President of India was to pass through that road. So therefore, an emergent tender was floated. Lords, we participated. The factum of work is there, my lords. The liability committee has approved the road.
Sir, had undertaken maintenance work of the road in next 80-136 kilometer. On an emergency basis. The work was stated to have been inspected on 8/9/2017. The official respondent stated to have certain alleged shortcomings while executing the maintenance work. Therefore, they have initiated proceedings to blacklist the petitioner. And the petitioner has been blacklisted on 3/12/2020 by memo 8095 within bracket capital E passed by the engineer-in-chief works
management
within bracket works management road construction department, government of Bihar. He had a grievance, he had a remedy of appeal against the blacklisting order. On the other hand, he had approached this court. This court disposed of his writ petition while relegating him to appellate authority. The appellate authority the petitioner filed his memorandum of appeal before the appellate authority. which is running to 16 pages. The appellate authority rejected the petitioner's appeal dated appeal on 26/10/2022. Hence the present writ petition. On 22/3/2023, the following order was passed. Counter affidavit has been filed. Perusal of the counter affidavit, it is nothing but improving the impugned order dated 26/10/2022. When the appellate authority's order is amenable to writ jurisdiction, in such an event, the appellate authority, while exercising quasi-judicial function, is bound to consider each and every contention stated in the memorandum of appeal. In other words, appellate authority order cannot be improved by furnishing any other material. Next, Apex Court in the case of Kranti Associates, para 47, it is held as an next, Apex Court in the case of
UMC Technologies.
Technology, so and so. Examined elaborately to insofar as blacklisting the issue is concerned. Perusal of blacklisting order read with the appellate authority order, it is evident that the ingredients with reference to judicial pronouncement the blacklisting authority, namely engineer in chief and so also appellate authority, have not taken note of this stuff. Next, gist of the various judicial pronouncement on blacklisting are as follows. Therefore, the petitioner has made out a prima facie case so as to interfere with the appellate authority order dated so and so and annexure so and so. It is set aside and the matter is remanded to the Principal Secretary, Road Construction Department, Government of Bihar, Patna, to undertake a fresh exercise of considering the petitioner's memorandum of appeal dated 28/3/2022 afresh after considering each of the contentions stated in the memorandum of appeal. So the above exercise shall be completed within a period of 3 months from the date of receipt of the order. Accordingly, the petition stands about.
The adjudication order, which Lords is pleased to see, it is absolutely illegal order, Lords. The adjudication order, the original order, that is absolutely illegal order, Lords.
We can't. Appellate authority's order is required to be.
Number 42, Mrs. Pontic under British versus not their participation for the
Lord, we have prepared the rejoinder to the counter. May I file, my Lord, the rejoinder?
We have filed an application on respondent number 1 and 3 below for vacating the interim order and also the counter, but although a status is not, perhaps it is before your lordship. On Monday we had hard copy we have filed yesterday. Online it is not being
Now pleading is complete, the case itself can be disposed of.
No, there is an interim order here, and they have themselves admitted that there is already on 31st of March, the one party has been declared L1, though there will be 4 persons to be considered. But because of interim order, we are not finalizing the matter. The price bid was...
No, the writ was filed much earlier.
What is the reason for disqualifying petitioner?
Lordships, if I may intervene, Lordships, I have received, my company has received, is the L1 bidder, Your Lordships. So my company has received the letter for negotiation.
So who has to answer this disqualification?
No.
I am only on the point, Your Lordship, that Intelligence part is a necessary party in this case because already we have been declared L1, Your Lordships.
Sir, what is that court is asking? Who has disqualified? Which respondent has disqualified the petitioner?
That is not, we are respondent number 1.
What is the reason?
The reason is, Lord, that the petitioner did not comply with Section 3, Clause 8.1 and 8.3e of the bill.
So as from there.
Lord, may I give the rejoinder in the meantime? Rejoinder to magistrate's counter. Okay, pass on.
Counter affidavit is filed on what date?
On Monday, my lord, hard copy has been filed yesterday.
That is also not there.
And an application for IA we have filed for vacating the order.
All those materials are not on record.
That blood is not showing so. The joiner we have just not received.
No, you file it in registry.
Very
is on record.
Very good. I'll file. So इसको मंडे को सुन Tuesday will not.
Lordship, in the meantime, Lordships to give us a copy so that we can.
Necessary party will not know contract.
Well, at least we can, because our rights will be affected by the outcome.
Party?
No, my lord, we have not been.
Then what is your how open your mouth?
My lord, because your lordships, we have been given.
No, first of all, what is your locus?
Locus, we were participants in the tender.
Are you being included as party?
No, Lordship.
Have you made an application for including your?
Lordship, today itself I have got the Vakalatnama. I am making an application.
File it.
My lords.
Respondents were stated to have filed counter affidavit. So also interlocutory application for vacating the interim order. The same has not been tagged. So registry is hereby directed to tag the same. So today, land counsel for the petitioner intends to file a rejoinder to the counter affidavit and objections to the interlocutory application for vacating interim order. The petitioner counsel is hereby directed to file it in the registry by Monday. Release this matter on Wednesday.
Lord, the interim order may continue. There is some.
Not there.
Lord, the interim order. It is till the next date of hearing. My lord will just.
They have admitted, my lord, in their supplementary affidavit that the on 20.
My lord, I will show, my lord, how he is favoring me.
For 1 week, nothing will happen.
I am the petitioner.
Really, my lord, we have.
I am the petitioner. My friend does not permit me to speak. That's the whole difficulty.
Really, my lord, we had called for the tender for 1 crore 12 lakhs of.
So can you decide now? Wait for a few days.
Serial number 43, Manoj Kumar Yadav versus the State of Bihar for the petitioner Vivek Kumar.
On the proposal, go and give your reply.
Lordship, but the proposal
Petition is premature. Go and make your explanation.
Your Lordship may give that liberty to me.
No, that is always there. Why we should express all those things? Writ petition is not maintainable. Better you withdraw this instead of adverse order.
Lordship may give me the liberty to.
No, liberty is also will give. Why unnecessary such writ petition is to be entertained? Instant petition petitioner has prayed for the following relief.
He even filed appeal, Your Lordship, there against.
Not against this. Not against this.
No, this is only a recommendation, I say.
I do.
There is a question of appeal against the recommendation.
An order.
Saying appeal.
An order has been passed, my lord.
Blacklisting him.
No.
The proposal is for blacklisting.
There against he went in appeal.
Where is the final order in the blacklisting?
No order.
Then where is the question of appeal? Instant petitioner has prayed for the following relief. Perusal of the relief sought in the present petition. The only petitioner has assailed the order of recommendation to blacklist him. The present writ petition. Courts have time and again held that against the show cause notice, writ is not maintainable unless and until such notices are in violation of the rules or a statute or issued by an incompetent authority. Both the ingredients have not been indicated in the present writ petition. Therefore, writ petition stand dismissed as premature, reserving liberty to the petitioner to furnish is a detailed explanation as and when show cause notice is issued by the competent authority to in proposing blacklisting. Oh, is he competent authority? Recommending authority. At this stage, we notice that recommendation order dated 23/2/2023 consisting of two parts, namely cancellation of contract and
in fact, my lord, what I
cancellation of contract against which petitioner has a remedy of appeal, and it is learned that he has already exhausted and suffered an order, and it is not the subject matter of the present writ petition insofar as challenging the appellate authority order. Therefore, the present writ petition is restricted to only with the issue of blacklisting. Insofar as the proposed blacklisting is concerned, the present writ petition is premature, reserving liberty to the petitioner to assail the appellate authority insofar as cancellation of contract.
Case number 44 is also the same matter. My lord.
Then where is the appellate authority?
That is page 26, my lord.
22nd.
Next matter, yeah.
कौन कौन है दीदी?
सर क्या आप सब पूरा मैटर मुझसे
Already availed remedy for the appellate cancellation of termination. That is a separate issue.
Case number 44, Manoj Kumar Yadav versus the State of Bihar.
Identical issue.
Identical issue.
Same petition, my lord.
Same order.
Yes.
The headings for hearing serial number 45, Manoj Kumar Yadav versus the State of Bihar for the defendant Srikundar Kumar Singh.
Yeah, please.
My lordship, for set aside the order dated 31/7.
My lord, in this case, I am appealing on behalf of the state my lord. I clear for 1 week time since my file is missing.
You are not missing. Only your file is missing. 2017 matter.
My lord, there is limited period made by the appellant, my lord. The state official is ready to demarcate the lands, my lord. Appellant as well as respondent, I both are.
Matter relates to selection and appointment. Selection and appointment.
In the land dispute matter, my lords, the petitioner before the writ court claims that certain piece of land was settled to him, my lords, and this appellant.
This matter is land.
My lords.
Land dispute.
Land dispute.
How writ is maintainable?
Lord, the writ court, before writ court, the petitioners came with an order of DCLR, whereby the DCLR, while staying his earlier order, further directed.
No, sir. First of all, how writ is maintainable? Writ petition by the petitioner.
Lord, sir, I have responded there.
They must have a remedy before some tribunal, land tribunal.
Of the Act, my lord, Bihar Land Dispute Resolution Act.
Now you are opening your mouth. Who is the contesting respondent? Who is appearing for Brahmadev Yadav?
Brahmadev Yadav.
I am appearing now.
You want time? You want to get instructions?
State is there last order में kindly see
How writ is maintainable, sir? You have a remedy before the tribunal or some authority. Joint register has passed the order. Against that, you must have a remedy before the commissioner or land tribunal. He is a respondent.
No, he is petitioner, my lord.
No, Brahmadev Yadav.
Brahmadev Yadav.
You are the writ petitioner.
But
You have to answer how the writ is maintainable. State Council, there are no judicial order on this point.
Under section 14 of the Act, Bihar Land.
All right, sir, there are no judicial order, judicial pronouncement of this court. So as to say whether matter is covered or not. You want time. Why can't you get ready for, on all those issues?
My file is missing, my lord.
File is missing. If file was there, you would have addressed. Yes, you must be expert, no?
I'm sorry.
What is the remedy in respect of joint register, in respect of land is concerned? How it is maintainable?
My lord, I believe against the orders that are passed by the revenue authorities, there is an appellate provision also made, my lord.
That is what?
Under section 14, my lords, under
It is
under
there, and
section
I
14
believe
of
there is also a
Bihar
tribunal, my
Land
lord, that has
Dispute
been, a
Resolution Act
tribunal has also
2009.
been, a tribunal, my lord, I believe has also been created for the purpose of redressal of those grievances.
The State Council is hereby directed to apprise this court as to how writ petition is maintainable. Against the orders of the revenue authority to apprise this court with reference to relevant provision of law, and so also any judicial pronouncement state of hearing. When are you able to get the file? Have you given police complaint? For missing file, you don't give complaint.
In office, my lords. I will search it.
Misplaced file, my lord.
In normal course, person is missing, we don't give complaint. There is a question of giving complaint in respect of missing file.
Misplaced file, my lord. It is misplaced in the office. This is what he was trying to say.
This after 2 weeks. You don't get a copy of the writ petition and papers from your brother and get a Xerox copy.
Guilty, my lord. Building land tribunal is there, my lord. Bihar land tribunal, my lord.
Bihar land
tribunal is there, which is headed by my lord, retired judge of this honorable court. That is the.
Then how writ is entertained? Then why have you taken such contention before the learned single judge? He cannot decide the title. Civil court is the one who can decide. So, without authority on the point, it could be anything.
इधर बना है ये
Serial number 46, Kamal Kishore Prasad versus the State of Bihar and the
Who has to answer?
But we have already answered. The state government has already taken decision that his appointment was not on the sanction post. Therefore, the liability to the state government is not.
If his post is not sanctioned, why did you assign the pay scale?
That the university has appointed, and why the Honorable Reed Court has.
But you have provided the budget.
Budget provided in general, my lord, not for particular post.
Then there is no audit of the university. Audit report is not submitted to the state council, state government.
That was the Honorable Reed Court has already decided against the appellant, my lord, that his appointment was not in accordance with law. Because
then he will be sent home.
No, my lord, Honorable Reed Court has protected his pay scale. What was drawing?
So when his appointment itself is not regular, where is the question of protection of pay scale and other things? What was the post held by him?
Football coach, my lord. That is not sanctioned. Football coach. That is not sanctioned.
Football coach. So you want to kick him?
He already retired, my lord.
Already kicked?
He had retired in the year back, my lord. And it has been fixed, whatever he was lastly getting, that was the pay scale of 6,500, that's 10,500.
Dismissed.
14 PTI inspectors are getting higher pay scale from the very same date. At least he should be given similar treatment too.
No, first of all, you are not eligible to hold the post.
My lord, after a lapse of more than 30 years, the post itself is not getting recognized. The petitioner, the appellant has lost the identity itself. So at least after when he has
First of all, where is the identification given by university that football coach so and so pay scale?
Certain recommendations were made, but that was
no mere recommendation is not sufficient. Post is required to be created, pay scale is required to be assigned, and it must be approved by the government.
As
so means you don't have case. Whatever the benefit you have already availed.
Appeal has resulted in a series of unfortunate events. My lord, the pay scale of the Vijayan Pratap has also been terminated, and
because of you, he has to suffer. His pay has been reduced. There may be a slogan. If you are taking one of my eye, the other person will take both the eyes.
Otherwise, he is totally.
We must appreciate that. This file is pending since 2011. You have maintained.
Apart from the post not being sanctioned, he is totally eligible for a higher post, for higher pay scale, my lord.
In terms of affidavit, you reject.
Heard, result.
Number 47, Kirana Singh others versus the state of Bihar others for the appearance within Bihar state.
Asking for
setting aside the order passed by the Honorable Single Judge Milord on 28/9/15 Milord. The petitioner are the SI Sub-Inspector Milord. He has been appointed on the post of the Sub-Inspector. Thereafter his promotion was to be made Milord. And after that he is claiming before the Honorable Single Judge for the promotion of the scale of the 10,000 to 15,200 Milord. And that was the Honorable Single Judge has passed order as page 21 of the appeal Milord. He has denied and the claim of the petitioner Milord. And the petitioner has been retired Milord. He has been appointed as a the petitioner was appointed and not to 9/2/75, and their first claim was 1987 Milord, and 2006 to 7 Milord. He has been promoted.
Sir, what was the pay scale given to you?
Milord, my pay scale was given to Milord. Page 7 of the LPA Lord Para second.
Oh, give the pay scale of which post? Sub-Inspector.
Sub-Inspector post, Lord. My scale was given to 65 to 10,500, Lord.
6500 dash 9000.
Consequently, RS 75 to 12,000 after complete 24.
Don't confuse, sir. 5500 dash 9000 was given to you, or you are entitled to that?
That is the first, Lord, that is given to me, this petitioner. Petitioner.
That has been given, that is wrong.
That is, as per the petitioner, that is wrong. They are entitled for 65 to 10,500.
Where is the material? You are entitled to 6500, not 10,500.
But the material is to fitment committee has been given, Milord. I have para second, Milord. May I read, Milord, page 7, Milord, of the appeal petition, Milord. That the serious errors of record while giving finding.
Para 7 of what?
Lord, para 7 of the appeal petition, LPA petition.
You are not going by appeal pleading and all. Where is the document to show that you are entitled to 6500 dash 10,500 in terms of so committee?
In read court, Milord, in read petition, Milord, para 5.
Sir, please don't show us the statement. We want document. Under which document you are entitled to so and so pay scale.
That is not Milord.
State Council.
Can
you assist?
Lord, on last occasion, Lord, I had referred Annexure A.
Annexure A of writ petition.
Counter affidavit, my Lord. I have brought on record the
Counter affidavit filed to writ petition or
LPA.
LPA. What is that Annexure A?
Annexure A 2.1.9, my Lord. There were separate pay scale for ASI and sub-inspector Millard. And on that fitment, based on fitment.
What is the difference between SI and sub-inspector?
Assistant sub-inspector. And there is sub-inspector.
Affidavit on behalf of respondent 3. Four.
It starts from page 30, my lord.
From this, what we can gather?
No, the correspondence page after promotion was given, my lord. I have already summarized in para 8 of the this counter affidavit, my lord.
We are not able to understand.
Lord, the pay scale is for ASCP, my lord. The pay
Get an officer.
Lord.
Get an officer from the department who is well conversant. Otherwise, you are also 0, we are also 0. For the state is hereby directed to secure one of the official who is well conversant with the matter relating to pay fixation, so as to understand and resolve the present case as to whether the petitioner is entitled, sorry, appellant is entitled not in the present list or not. Which department? Police department.
Home department.
Don't get a police department official. Get an official from the finance department. They have a rich experience.
Hello. 2 weeks. 2 weeks.
My God.